I beg to mention item number 10, 11 and 12, my lord.
Item numbers?
10, 11 and 12, my lord.
10, 11, 12.
12. Well,
Yes.
we are directed to file a affidavit by the commissioner, Guwahati Municipal Corporation. He is out of station, my lord. Lordship, allow me 10 days time. He will join it.
Who is appearing for the petitioner?
Petitioner MJ Burua.
Have you informed them?
Well, I have called him, but he is not picking the phone.
No,
but the
then
other
you-
side has.
Mr. Bora, in that case, you
Lordship.
please wait for your turn.
Lordship.
Yes.
May it please your lordship, my lord, item number 26, consent the my lord other side. My lord, taken up after long street, my lord.
Huh?
Time may be granted for after 2 weeks, my lord.
26. You government at the side.
Yes, ma'am.
What do you want?
For 2 weeks time may be granted.
As prayed for by Mr.
Jayat Hussain.
Jair Hussain, learned counsel for the petitioner, which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry. Yes.
May I please, Your Lordship? I beg to mention item number 14, my lord. In this case, Mr. Didas is some medical issue, Lordship, so may be taken up after 2 weeks, Lordship.
No, I am appealing for the GMC, my lord. The agency is sending a stay order. Lordship will fix it on Tuesday or Thursday, on 25th, my lord.
As prayed for
Lordship,
by
he has
Mr.
submitted a letter of absence till 26, my lord.
I will after 26th.
Lordship will fix a date, my lord.
I'm put a petitioner, my lord, on behalf of Didas, my lord.
ADAS.
Didas, Ditul Das, my
You are Mr.
R.K. Talukdar, my lord.
Mr. R.K. Talukdar submits that Mr. D. Das, the arguing counsel for the petitioner, is unwell
Lordship.
and accordingly seeks some accommodation in the matter. Stop. List this matter, prayer allowed, list this matter on
30th, my lord.
such and such
Interim,
date.
interim may be continued.
Interim, if any, shall continue till the next date of listing.
30th.
Yes, next.
Okay.
May I please, Your Lordship? Admission matter item 24, my lord. With the consent of other side, my lord, the matter will be taken after 2 weeks, my lord. My
You are
friend is
Mr. B.
B.
Raman.
Raman. Yes, ma'am.
As prayed for by Mr. B. Raman, learned counsel for the petitioner with consent of the other side, list this matter after 2 weeks on a date to be fixed by the registry. Next.
Thank you.
May I please your lordship, I beg to pray for listing an urgent matter for withdrawal.
Listing.
For
Li-
withdrawal. For withdrawal.
Yes, but there is a senior bench taking up the concerned bench. So you mention before the appropriate bench. Yes.
May I please, Lordship? Lordship, item number 19 may kindly be adjourned for that day.
Item number.
19.
Have you informed the other side?
I am for the petitioner.
You are for the petitioner.
Yes, yes,
What
sir.
about the other side is government?
Yeah.
department is also.
All right. You
M.
want
Rahman.
some time?
Yes.
As prayed for by Mr.
M. Rahman.
So and so, learned counsel for the petitioner, which is not objected by the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
May I please your lordship, I would like to mention item number 28. Kindly adjourn the matter for 2 weeks.
You are for?
I'm for the petitioner.
For the petitioner. Why do you want time?
Lordship, we have to take instruction.
Your name?
SS Bora.
As prayed for by Miss 2828, right? As prayed for by MS.
SS Bora.
So and so, learned counsel for the petitioner, list this matter, which is not objected by the other side, list this matter after 2 weeks. After 2 weeks on a date to be fixed by the registry.
May it please your lordship. Lordship, I beg to mention item number 37 of the daily list.
37.
Yes, my lord. Lordship, CD was...
37 is an anticipatory bill.
Yes, my lord. CD was called for, but I believe CD is not available.
Not available. In
Lordship,
item,
I'm on interim, my lord.
in item number 37, await CD, list on such and such date, interim if any shall continue till the next date of listing.
5th August.
5th August.
Yeah, please, Your Lordship. Lordship, I beg to mention item 43. Your Lordship, this matter become in progress as the grievances raised in this petition has been addressed, Your Lordship.
Your name?
S.K. Chakma.
SK? You,
43.
your name is not in the cause list?
Not in the cause, please, Your Lordship. I'm mentioning on behalf of D. Ghosh.
Mr. So-and-so, learned counsel, appears on behalf of MSD Ghosh,
Yes,
learned
sir.
counsel for the petitioner. Stop. All, anybody else appearing in this matter? Mr. Gupta, Deori, Dubey, are they there in court? Government, MS, and also heard MS.S. Borwa, learned government advocate for the state respondent. Next para. Mr. So-and-so, learned counsel for the petitioner, submits that the matter has in the meantime become infractious and accordingly makes an endorsement to the same effect. Stop. In view of the aforesaid endorsement, the writ petition stands dismissed for being infractious.
Deeply honored.
May it please your lordship, with due consent of the other side, I beg to mention item number 36 of the daily list, my lord. We have received our up-to-date instructions, my lord. I am praying for 2 weeks' time to file our affidavit.
As prayed for by Mr.
H. Borua.
H. Borwa, learned standing counsel.
No, my lord. I am appearing on behalf of B. Chaudhary,
He is the standing counsel.
Standing Counsel, Finance and Taxation Department.
Learned Standing Counsel, Finance and Taxation seeks 2 weeks' time to file, submits that the appropriate instructions for filing affidavit has been received and accordingly seeks some accommodation in the matter. Prayer is not opposed. List this matter on after 2 weeks on any date fixed by the registry. Yes.
Highly obliged, my lord.
Item 10, 11 and 12, my lord. I'm looking just now, my lord. My friend is appearing, my lord. Given the consent, my lord.
You
Let it
found
come.
them. As prayed for
10,
by
11.
Mr. S. Bora, learned counsel for the respondent
GMC.
number
GMC, my lord.
3 and
3 and 4.
3 and 4, which is not opposed by the other side. List this matter after 2 weeks.
10 days, my lord. In the meantime,
After 10 days.
10.
After 10 days on a date to be fixed by the registry. 10, 11 and 12.
Okay.
Yes, call the list.
So far as the stay vacating petition
Yes,
is
Mr.
concerned,
Barbara.
some recovery was made from a contractors. This court, my lord, prevented them from recovering by way of an interim order. By the time, my lord, the order was passed, they already recovered. And therefore, in the IA petition, they have kindly have a look at the IA at page.
This IA is for vacating the
Vacating
stay,
the-
whereby the recovery was was
Yes,
stayed.
but that stay order was not effective because already they have recovered. Therefore, the prayer at my
After
lord.
recovery of made, my lord, they came to this court and they ordered their
Who is the writ petitioner?
I am married. So, my lord, kindly, IA, prayer may be seen. It is not existing anymore, my lord.
Page number.
Page 10 of the IA.
You have filed the IA. They have filed the IA.
IA, the main case is coming. Now, in any case, the main case will
According to you, this the prayer made in the IA has in the meantime become infractious.
have to... Yes, my lord, because it says the prayer itself is that order dated so-and-so passed by this honorable court to the effect that the amount of so-and-so being already recovered, said recovery shall be subject to the result of the writ petition and may further be pleased to allow the applicants fortnight's time to file their affidavit in opposition and please. They
What
have
kind
filed
of an IA is this?
only to bring to this notice of this honorable court, my lord, the recovery is already made because in the interim order
Anyway.
it was provided that no further action should be taken by the FCI in terms of the notice.
I think this IA can be disposed of.
My lord, entire
main case.
matter can be pleadings
matter.
complete.
That is first let us see what can be done in the IA. I think the IA can be disposed of by directing that since the recovery has been made, the set will
Yes,
be
yes.
Subject to the outcome.
Yes.
I don't think you will have any
it is
objection
not
to that.
surviving anymore, IA.
Yes, yes.
Main case lordship may take up.
Mr. Barbara, instead of saying it is not surviving, we can this court can
Yes.
just dispose it of by saying it is subject to. I don't think you have any objection to that.
No, my lord, it is subject to, and my lord, the
Correct.
main case may be taken up, my lord.
That maybe on a next date.
Yes, ma'am.
Today the IA is there,
Yes,
right?
yes, yes, yes.
All right, in the IA. This is IA 1149 of 2023.
My
Yes.
Heard Mr.
SK Chakraborty.
S.K. Chakraborty, learned counsel for the applicant. Stop. Also heard Mr. A.C. Barbara, learned senior counsel, assisted by M.S.N. Day, learned counsel for the respondent stroke writ petitioner.
Writ petition.
This interlocutory application has been filed seeking modification of the interim order dated 17/2/2023, 22/2/2023 and 3/4/2023 passed by this honorable court in WPC number 862 of 2023 in terms of the liberty granted by this court by order dated 22/2/2023. Stop. It appears that the amount of rupees 10,39,504.23 has already been recovered on 2/12/2022 and 31/2023, and therefore this interlocutory application has been filed seeking modification of the earlier orders to the effect that the said recovery shall be subject to the result of the connected writ petition. Stop. Next. Considering the in view of the above, this court is of the considered view that this interlocutory application can be disposed of with a direction that the amount recovered shall be subject to the outcome of the writ petition. Stop. Disposed of.
So, my lord, so far the
IA is disposed of. Yes, main case. Now give me the main case.
Lordship may fix a date for admission hearing because my money is being blocked.
This matter has not yet been admitted.
No, notice was given.
Pleadings are completed.
Yes, they have filed.
Yes.
You don't want to file a rejoinder?
Not necessary. Lordship may post it on as an admission hearing.
In
It can be
WPC
disposed of short matter.
862,
Otherwise,
heard Mr. A.C. Barbara, learned senior counsel, assisted by M.S.N. Day, learned counsel for the petitioner. Stop. Also heard Mr. S.K. Chakraborty, learned counsel for the respondent. Stop. I can admit and post it for hearing next week or after 2 weeks.
might be, my lord, as is convenient to be, my lord.
It appears that a full-fledged hearing is required.
Admission hearing, my lord.
Admit list for hearing on, yes, give a date.
Let it be on, my lord. Let it be on
Such and such
31st July.
Okay.
Admission hearing.
Okay.
Yes. Obliged.
No steps, item 2.
Yes.
Lordship, in this matter, we have taken steps, Lordship. We have taken steps on 28/5/2019, and the last order was
You have taken steps.
Steps.
When?
28/5/2019.
But here it says you have not taken steps. The section has not received. Okay. Your name? Your name?
P. Chakraborty, Lordship.
Mr. P. Chakraborty, learned counsel for the petitioner, submits that steps has been taken on
28/5/2019.
on 25
28/5/2019.
on such and such date in respect of respondent number 1B.
Yes, Lordship.
Stop. However, the office note dated 26/6/24 does not. However, the office note dated 26/6/24 reflects that no steps has been received by the section for issuance of notice upon respondent number 1B in correct address. Stop. Have you stated the correct address?
Yes, Lord.
Stop. Let registry verify and do the needful.
You oblige, Lord.
I've taken steps today morning.
Mr.
Ezehal.
Mr. So-and-so, learned counsel for the petitioner, submits that steps has been taken today.
Yes.
Stop. Let registry verify and do the needful.
Highly appreciated. Some series of matters are pending before this honorable court. Let the matter be tagged along with
Let first registry verify.
Lordship. Highly appreciated.
Lordship, may I pray for a Passover, Your Lordship, for some time, Your Lordship.
May I please, Your Lordship? In item number 9, Lordship, 8, Lordship, I am for the petitioner, Lordship. In this matter, we need 10 days time to file our affidavit in open.
In which one? In item number 9?
In item number 9, I am for the petitioner, and Item number 8, Lordship, my learned friend DJP.
I am the petitioner and
You want time in which one?
In item number 8.
In 8. You want time to file
In
affidavit.
opposition, Lordship.
I have filed the affidavit during the course of the day. I will file it.
You have filed affidavit in item 9.
Item 9, my lord.
Let me do one by one.
Lord.
First in WPC 1650 of 2021. Your name?
N.K. Sharma, Lord.
Mr. N.K. Sharma, Learned Counsel for respondent number 4 seeks 2 weeks time to file affidavit in opposition in the matter. Stop. Prayer is not opposed. List this matter after 2 weeks on a date to be fixed by the registry. Next, in WPC 253 of 2021, Mr. D. Chaudhary?
D. Chakraborty.
Mr. D. Chakraborty, Learned Counsel for the respondent 8 submits that necessary affidavit has already been filed.
Will be filed during the course of the day.
That affidavit in opposition shall be filed within the course of the day. Stop. In view of the aforesaid endorsement, list this matter after 2 weeks on a date to be fixed by the registry.
In item number 9, there is an interim order, Lord.
In item 9, if interim, if any, shall continue till the next date of list.
Deeply obliged, Lord.
Obliged.
Yes.
Lordship, the respondents were supposed to file their affidavit on the last occasion.
Yes, where are the respondents? On the last occasion, there was no representation on their respondents.
From somebody from the respondent side.
Yes, Finance, Government of India.
I can appear for the Government of India, but for GST there is standing counsel.
No, on the last occasion also there was no representation.
From GST.
There was absolute no representation for all the respondents. Because this is a matter which had come up on the returnable date. So, are they interested to file returns or not? You will appear for respondent number?
Only one.
Only one. But I think the contesting respondent is the GST department.
Yes, sir.
Who is appearing, Mr. KL?
Yes.
Can you please ask someone to...
For GST, it's B. Chaudhary.
Mr.
For GST, for the State Council, it's Mr. B. Chaudhary.
Bikram Chaudhary.
Yes,
Can you please call him? Wait for us sometime.
Yes, yes, sir.
15.
May I please, Your Lordship?
Yes. Have you?
The writ petition can be closed on the basis of these two letters.
GMC, anyone there? Mr. Bora, is he there? In this, Mr. Nayak can appear.
The petition is against the enhanced rate of the Fancy Bazaar New Market, and on 27/3/2023, the GMC authority decided.
I have not understood anything. Yes, what is this case?
The petition is against the enhanced rate of the Fancy Bazaar market by the GMC authority. The GMC authority enhanced the rate from ₹3 per square feet to ₹38 per square feet, which is they became equal to the other GMC markets. But this new market, GMC new market, is not equal to other GMC market because only the plot of land was of GMC, but the whole shops were constructed by the petitioners themselves. Therefore, this petition made, and accordingly, on 27/3/2023, the GMC authority newly declared the enhanced rate, and serial number 3, new market GMC market Fancy Bazaar, that was decided as ₹3 from ₹6 per square feet. So on the basis of
No,
this,
old rate was 3.
Yes.
Now new rate is 6.
Yes, correct.
So they have enhanced to 6.
no, earlier they made ₹3 to ₹38 per square feet. That's why we filed this writ petition. But after that, there is a discussion, and accordingly, newly modified rate was decided.
On which day?
On 27/3/2023.
Mr. Nayak, you have a copy of this notification?
Yes, Lordship.
You have it?
No, it is with the discussion of the petitioner's Lordship,
Yes,
this new enhanced rate is arrived at Lordship.
The enhanced rate is what?
Rupees 6.
6 per square feet.
So they are satisfied with this.
Yes, Lord.
It was,
So therefore nothing survives
Yes,
for
Lord.
adjudication. I'll close
Yes,
it.
Lord.
Yes, Lord.
Heard MS
R. Doctor.
R. Doctor, Learned Counsel for the petitioners. Stop. Also heard Mr. P. Nayak,
Lordship, GMC.
Learned Standing Counsel, GMC. By filing the instant petition under Article 226 of the Constitution of India, the petitioner is assailing the action of the respondents in enhancing the rent of the rooms of the petitioners with a notice dated 22/7/2020 situated at New Market, Fancy Bazaar at par with the other markets of Guwahati Municipal Corporation without taking note that the lands were allotted to the petitioners and the petitioners had constructed the rooms at their own cost and the respondents are legally entitled to only the rent of the land and not the rent of the rooms. Stop. Today when the matter was called for admission, MS R. Doctor, Learned Counsel for the petitioner submits that during the pendency of the writ petition, the office of the municipal corporation modified the earlier order dated 21/7/2020 and refixed the rent of the
Fancy Bazaar.
rooms of the petitioners. Stop. Correct?
Yes, Lord.
A copy of the office order dated 23/3/2023 along with the fixation of the new rate by order dated 27/3/2023 is placed before this court, which is kept on record and marked as X. Stop. Mr. P. Nayak, Learned Standing Counsel, GMC, also endorses to the same effect. Stop. In view of the aforesaid, it appears that nothing survives for adjudication. Accordingly, the writ petition stands for being infructuous. Disposed of date. Mr. Chaudhary, you are appearing in this?
No, Lordship, it's a central GST, Lordship.
Who will appear?
She will be.
Lordship, my senior instructed me to submit this judgment, Lordship. Similar,
Submit judgment.
Yes, Lordship. Similar order was passed by the Honorable Supreme Court, Lordship.
Ms. Bhattacharya, is this case covered by this judgment?
Lordship, I have not gone through the judgment.
You give it to her first.
Lordship.
And
I will give.
before you give anything to the court, you have a duty to give the copy to the other side. You cannot take the other side by surprise. Please give a copy to Ms. Bhattacharya. You have a look at it. I'm fixing this.
Anytime next week, Lordship.
Or otherwise you have a look at it and we can call it again. If it is covered, we can dispose it off.
Lordship.
Have a look at it.
Sure.
Don't go away. You take her number. Both of you come together and inform my court master. Then we'll call up the matter.
Yes, Your Lordship.
You are excused. You are not there in this matter.
Highly obliged.
Lordship, my name, I think so, Lordship will be disposing of.
Item 16.
None appears for the petitioner when the matter is called. Stop. MS S. Borwal, Learned Government Advocate, along with MS N. Borderloy, Learned Standing Counsel, Revenue and Disaster Management. You there? And Mr. P. Nayak, Learned Standing Counsel, Finance, are present. In view of list this matter on the next Friday, on such and such date, under with remark within quotes for dismissal.
17.
May I please, Lordship?
Also, this is GST matter. The petition has been filed because interest has been demanded, not till the date of payment, but till the date of filing of returns.
Affidavits not filed?
Affidavit not filed, Lordship. Some notification has been passed, Lordship. Some relaxation has been made, Lordship. So, Lordship, this matter may be fixed some other day.
Lordship will be able to dispose of this matter perhaps next week, because today Mr. Kyal is not available. Because there is a notification which has given relaxation, and there are two judgments of High Courts, Madras High Court and
It is submitted at the bar that...
D. Sara.
No. What are you submitting? What notification?
Lordship, amendment has been made to
It is
GST.
submitted at the bar that an amendment has been made giving relaxation
in respect of interest.
In respect of
interest to be charged from the petitioner.
to be charged from to be
assessors
charged.
like the petitioner.
Stop. However, the said notification, however, the parties seek some accommodation in the matter to place the said notification on record. Prayer allowed. List this matter. Yes, Mr. Bora.
This matter challenges an arbitrary action of the state where I was dispossessed from the government land. Without any notice, my permanent structure were broken. Now the parent question is whether notice is required or not. Admittedly, they say that no notice is required.
What has been, you have been dispossessed?
Dispossessed. And arbitrarily, without anything, even
You
an
have been
order.
dispossessed from where? From
a land which I am my predecessor was occupying from 1980. I am occupying from 2016. Now there
you
was
are occupying the land on what basis?
it's a possessory right. It's a,
Possessory
admittedly a land.
And your possession has been disturbed without giving you any notice.
Notice, not even notice. There is no order. There has to be some order.
What is your stand, Ms. Borua, in your AO?
Yes, Lordship, our stand is in page number 43, paragraph 4, Lordship.
Page number?
43. Paragraph 4.
Yes.
And the answering deponent respectfully states that the land in question over which eviction was carried out does not fall in the DAG number 297, but same is a part of land of DAG number 296, which is a land reserved for a road. The deponent further states that the petitioner is not entitled to possess the said land. The occupation of the petitioner and of Sri Bhushan Singh is illegal, and their status is that an encroacher of land reserved for road.
Even assuming he's an encroacher, can you dispossess him without giving him a notice?
Yes, he is in the own government land, Lordship. Therefore,
I've understood, but
yes.
Will notice not be required?
No,
can you because his allegation is that you have dispossessed him by without giving him any notice.
Yes.
Can that be done? Yes.
Lordship, recently this point was taken up by the division bench in a matter which was recently judgment where it says, Lordship, I have not got hold of the judgment, but I have asked from the counsel who was arguing this matter. The court has said that a notice would be required, even an inquiry is required.
Correct. How can otherwise everybody will be, it will create havoc. One will just, on the garb of being encroacher, one will start evicting people. That cannot be. There has to be some procedure, Ms. Borua.
Yes.
So, in your affidavit, have you addressed that issue? On
No.
how have you dispossessed? Because that is an admitted fact that you have evicted the petitioner. This
Yes,
is
sir.
why the petition has been filed, correct?
Yes.
Now, in support of this, you are saying he's an encroacher. All right,
Yes.
assuming he's an encroacher, but how have you evicted him? Did you follow any procedure? What procedures have been followed?
After the demolition and eviction, I filed an RTI seeking whether, because bulldozers were used, whether there was any order from the Deputy Commissioner's office to evict me, or whether the bulldozers that were used, where it is sanctioned or not. There was no record of such eviction.
Where is that? Ms. Borua, please have a look at your affidavit and
Yes, Lordship.
point out that paragraph. In the meantime, Mr. Borua, where is that?
Yes, yes. RTI is at page 27. 27 is my question. N, column N, whether any proceedings was initiated against the appellant.
Column?
Column N.
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 At
Specific
page
details
27.
of 27.
There's two column N here.
1,
1, 2, 3, 4.
1, 2, 3, 4. That is my questions.
Huh.
In reply, Lordship would see page 29.
Yes.
To the additional, with reference to the subject, I have the honor to enclose here with a copy of the RTI submitted by Kanai Yadav, so and so, this under 6.3 for favor of your kind information, necessary action, as the information sought by the applicant to your department branch. You are requested to furnish the information directly to the applicant under 7.1. At that office, there was no information. That therefore, I was transferred. Now they could not furnish any order. Lordship.
Yes, Ms. Borua.
Yes, one communication is received from SP Tinsukia Lordship. They have lost, no any FIR was lost, Lordship, and the eviction means encroachers where eviction is not is made submission falsely.
I have not followed. Eviction?
Eviction, petitioner submitted that the construction was broken and bulldozers, that are not true.
No, that is subsequent. First, how did that action, how was that action taken? It has to be preceded by some notice. You cannot just go with bulldozer and start doing
Yes.
something, or because it is admitted that he has been evicted. That
Yes,
much is
evicted.
admitted. So the only question the court is putting to you is how it was done. Was notice issued or not issued?
Yes, that notice not
What
mentioned
procedure
in
have
our-
you followed?
That is not
We are not
mentioned in-
going into the bulldozer as of now. But the first thing that you need to satisfy is that you must have followed some procedure.
Yes.
You cannot deprive him without following any procedure.
Yes, Lordship.
How can you do that?
Lordship, at para 5 of their affidavit, they say that no notice is required. Lordship. I read
Yes.
para 5 at page 44. Third line.
Para 5?
Para 5, page 44. And I have filed an FIR. I have
One
enclosed-
second. Para 5, yes. What?
Third line
Settlement
states that the
rules
eviction
on
process was
Bangkok.
carried out as
Settlement
per
rules.
law and with conformity with 18.2 of the settlement rules under Assam Land and Revenue Regulation 1886, and under this rule no notice is required to be served. The deponent further states that police authority did not assault anybody, nor any property books were damaged, destroyed, or no one.
What is your reply to this paragraph?
Lordship, yes. My reply to this paragraph, Lordship, would see at page 50. What is it? Yes, Lordship, page 52.
Page 52 is not here.
Reply, my reply at page 52.
Reply to 9 here. Oh, ulta ka छोटी सा
Lordship, I have quoted the rule 18.
Rule 18 to write it. Paragraph?
Page 52, para 3, it starts.
Yes.
Firstly, I have quoted the rule. Thereafter, at page 55, I have made my statement. judgment. Page 55. May I read?
1 second. Let's see the rule first.
Yes. Lordship, I have quoted it at page 53.
Yes, I have the book, you can read.
Yes.
You can read.
Subject as herein provided, the Deputy Commissioner may eject any person from the land over which no person has acquired the rights of a proprietor, landholder or settlement holder. Where such person has entered into possession of a government khas land or wasteland or state over which no person has acquired the right of the proprietor, landholder and settlement holder, or any land that has previously been reserved roads or roadside land, or for grazing of village cattle or for other public purposes, or has entered into possession of land from which he has excluded by general or special orders, or when further there is no bona fide claim or of right involved, he may be ejected or ordered to vacate the land forthwith, and the Deputy Commissioner may sell, confiscate or destroy any crop raised or any building or any other construction erected without authority on the land.
So in case of a reserve road, notice is not required.
Yes, sir.
This is what subsection 2 of 18 says. Correct?
Yes.
If the possession is over a land which is reserved for road,
yes,
in that situation notice is not required.
Yes.
One can be evicted without notice.
Yes.
And subsection 3 says in all other cases ejectment shall be preceded by publication of a notice.
Publication of
Correct?
Yes.
So what is your
here
reply?
the facts, Lordship, is not
after
notice is the second part of it. First, there has to be an order to vacate. Whether suppose there has to be order that you are occupying a reserve road or a government land or a government khas land, you please vacate. That order has to be there from a government authority, that is the DC or SDO or a circle officer. That order is not there, firstly. Secondly, after that, whether notice is required is the second thing, which is now well settled because of the division bench judgment, which says under 18.2 also notice is required. And moreover, Lordship would see that where there is no, under 18.2, where there is no bona fide claim, then no notice is required. Lordship, I will read it again. Where there is no bona fide claim, when further, Lordship,
yes,
when further there is no bona fide claim or right involved, he may be ejected. Now, there was a scheme of the government where we can apply for patta. I have given my application which is pending consideration, which is also annexed to this writ petition. Now, so there is some bona fide claim also.
Where is the order of the Deputy Commissioner?
That order is not annexed, Lordship. Not annexed, Lordship.
Not annexed.
Yes.
Is it there? You have not referred to that order
Yes, Lordship.
in your affidavit in opposition. Have you referred?
No,
If it is not referred, this court will assume that means there is no such order.
I have to take instruction regarding this, whether order was passed or not. If order was passed, then I have to bring the order.
Affidavit more reply on there.
In
Reply.
Ms. Bora, I don't think there is any order.
Lordship, at page 59, I have in my reply, I have specifically taken that plea that
There is no order. It's sine qua
there
non.
is no order.
I have read it. Yes.
so accommodate time, accommodate
I
some time.
can do one thing. I can post this matter for orders on Wednesday. In the meantime, you can find out if there is any order.
Yes.
Yes.
You can do that. We'll give them a one last chance.
Yes.
To item number 18. Heard heard Mr. B.P. Bora, learned counsel for the petitioner. Stop. Also heard M.S.S. Borwa, learned government advocate for the state respondent. Stop. You are appearing, Ms. Bordler, and M.S.N. Bordler, learned standing counsel, revenue and disaster management. Stop. This matter was taken up for hearing at the admission stage. Stop. The only point urged by the writ petitioner is that the petitioner has been evicted from the subject land without being preceded by any order from the Deputy Commissioner, which is the mandate under Rule 18.1 and 18.2 of the what is this rules called?
Assam Land Revenue.
Of the Assam Land Revenue Settlement Rules. Stop. A perusal of the affidavit in opposition filed by the state respondent does not indicate as whether any order was passed by the Deputy Commissioner before evicting the petitioner from the subject land. Stop. List this matter for further hearing on Wednesday or Friday, next Friday. Next Friday date today, on such and such date, on which date M.S.S. Borwa, learned government advocate for state respondent, shall obtain specific instructions as regards the order passed by the Deputy Commissioner in this regard.
Deeply.
Part heard.
Deeply.
Yes.
Timing 4 to 7.
ইফালে না 18ত আহোঁ গ'লে এইটো কোনটো হয় এইটো তাৰ
My Lord, in item number 4, I am the writ petitioner.
Yes.
And in the other writ petitions, we are respondents.
What are these matters?
My Lord, may I briefly indicate the background, my Lord? Now, this Purbanchal Griha Nirman Unnayan Committee, it's a society, my Lord, formed by persons who had they formed the committee to construct, a housing society, basically for their members. Now, Government of Assam allotted a plot of land measuring 30 bigha on payment of premium. Now, premiums were paid, lands were, allotted, revenue records were corrected, everything happened. Then subsequently, Assam government came up with a statute. Lordship knows that name of that statute was Assam Guwahati Water Bodies Preservation and Conservation Act.
Mr. Chaudhary, pleadings are completed in these matters.
Yes.
So I'll admit and post them for hearing.
No, my Lord, there is some urgency in the matter.
We'll give you a short date. We'll give you a short date next week or the week next. Huh?
In fact, there are some development in this matter. I would like, I'm petitioner in item number 7. There is some development from the government side. I would like to bring on record on.
In the meantime, you bring whatever you want to bring on record. I'm posting it for hearing.
My Lord, the only thing is, if your Lordship will kindly permit me,
yes.
Other than this, perhaps my item number 4 has become infructuous, but today that prayer I will not make. If your Lordship will kindly come to item number 5, please
5,
come to
which is filed by Mr.
Varsa Technotrend.
That is Mr. R. Majumdar.
Yes.
Where is he?
He's on legs in court 1, my lord.
Yes. What do you want to submit in
Yes,
this?
my Lord will kindly come to that writ petition. Come to the prayer portion, my Lord.
Yes.
At page 22.
Yes.
A writ in the nature of mandamus, any other appropriate writ shall not be issued. An appropriate direction to the respondent authority for reserving the land measuring 30 bigha covered by so-and-so, so-and-so, so-and-so from the purview of schedule to the act. Then 2, a writ in the nature of mandamus or any other appropriate writ shall not be issued, directing Guwahati Metropolitan Development Authority to accord permission to construct houses as per the approved plan upon the land measuring 30 biga. Then 3, a writ in the nature of mandamus or any other appropriate writ shall not be issued to allow the writ petitioner company to construct residential complex upon the land measuring so and so, so and so, so and so. Now the fact of the matter is, in view of the subsequent development, this entire 30 bigas of land has been acquired by the government for preservation of the water bodies. Because apparently, my lord, according to the government, according to the act, this land falls in the water bodies. Now the question is apportionment of the compensation which the government will give amongst the members of the society. That is the issue only left. Now going by the prayers...
Who are you?
I am, my lord, that Purvanchal Grihanirman Samiti, who filed item number 4. I filed the first writ petition where we pray that this land should be taken out from the purview of
the Water Body.
The Water Bodies Act. The reason is why, my lord, of course that I am not pressing now. Assam Land Revenue Regulation, it is a central act, my lord. It's not a state legislation. We all sometimes...
Assam Land
Yes,
Regulation.
Assam Land and Regulation 1886
It's a central act.
Yes, it was enacted with the concurrence of the Governor in Council as was the then available Mela. So this is a state act. By virtue of section 4 of the 2008 Act, overriding effect has been given.
To the
By a
central
state act, overriding effect cannot be given over a central act. Anyway, now those issues are over.
All right, Mr. Chaudhary, I think it will need some amount of hearing. I'm posting it for hearing.
Yes.
I'll admit it. In the meantime, parties are at liberty to file whatever they want.
Well, there is some amount of urgency.
Very well.
Not next week, following week.
All right. Heard, Mr.
And my lord, there is an interim order which is operating.
Very well. You are appearing in item number 4?
Item number 4 as a writ petitioner and in the other 3 writ petition as a respondent.
Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. Ajay Das in RJ Das for the Learned Counsel for the petitioner in WPC 7457 of 2018. And Mr. Who is the other writ petitioner? Yes, MS?
Yes, Diwa Pongla.
MS so-and-so, Learned Counsel for the petitioner in WPC 4395 of 2022. And in 6254? And Mr. A. Baswas, Learned Counsel, appearing for the petitioner in WPC 6254 of 2023. Stop. Also heard, yes, respondents.
I mean item number 7.
Also heard appearance. Please give your appearance slip. It appears that this writ petition requires a full-fledged hearing. Stop. Admit no formal notice. List for hearing.
Admission might take to hearing.
Admit a list for hearing on. Give a date.
Yes. My lord can have it on 8, my lord.
On 8 August?
Yes.
On yes, 8 August. Convenient, Mr. Biswas? 8/8/2024. Stop. Parties are at liberty to bring on record the development which is said to have taken place during the pendency of the writ petition.
My lord, in all the cases I have filed my affidavit where I have brought on record the subsequent development. Let them file their reply to that.
I think in the second case I find there is already a reply.
Yes, we have filed it.
You have filed it.
Yes. In all the cases.
Liberty to continue. All right.
Timing item 30.
Judgment which is given, this is on a different point, my lord.
On a different
Our
point.
case is whether it is eligible or not. Once it is held to be eligible.
Very well. Then, Mr. Sahewala, I am posting it on another date. Let Mr. Kyle be there. Because no affidavit otherwise has been filed here.
Yes.
You file your affidavit.
Lordship, allow us 1 week to 2
Your
weeks.
name?
M. Deka.
As prayed for by MSM Deca, Learned Counsel for the GST.
CGC.
For CGC, which is not opposed by the other side, list this matter after 2 weeks to enable the CGC to file their return in the matter.
Highly obliged.
Item 20.
Eviction?
Yes, Lord.
No returns filed?
No, Lordship.
Yes?
Railway is there, Lordship.
Railway is there.
Railway?
Railway is the main.
Who is appearing for the railway?
Lordship, notice was taken by Lordship, A. Gayan, Lordship.
Railway has only one advocate as a panel in the panel?
No.
Then why are there no representation?
He is there, Lordship.
Where? Bhattacharya, just wait for some time. Otherwise, it will make no effect.
21.
Yes?
Some person have already settled lordship.
Huh?
Some person of land only settled lordship by the respondent authority in the name of the petitioners.
So, are you withdrawing?
No lordship, they have total 9 bighas of land.
Some has been,
Yes,
so still something is surviving. Yes, returns?
Yes, Lordship. Instruction awaited, Lordship.
How much more time?
3 weeks time required, Lordship.
As prayed for by MS S. Borwal, learned government advocate, as well as MS N. Bordoloi, learned Standing Council, Revenue and Disaster Management, which is not opposed by the other side, list this matter after 2 weeks to enable the respondents to file their return on the next date of listing.
Oh, blessed.
22.
Where is Mr. Bucha?
He is not there, my lord.
He's not there. I have not seen him in court today.
Not
he has not come today.
We haven't seen him.
Yes. He was appearing in person.
Yes, yes.
I think then we will have it on another
Another
date because since he's appearing in person, maybe he has missed out. But was this matter fixed today? No.
It was.
Fixed on 26th of June. No. Anyway,
After $15.
petitioner in person is not present today when the matter was called. Stop. Respondents are all represented.
Petitioner number 1 is also absent. There are 2 petitioners.
I think only one used to appear, right, Mr. Deka? Last time you made an objection to that as how the petitioner in person can appear for 2. I remember. Petitioners in person are absent, are not present when the matter is called. Stop. Respondents are all duly represented through their councils. List this matter. Yes.
After $15, my lord.
Date did you after $15? So and so date, registry to intimate the order to the to Mr. B. Bucha and Mr. R. Sharma, the petitioners.
23.
Yes, Mr. Akan. Returns. Yes. Who's filing? Finance and government. This court will not be waiting for you all. If you want time, please ask.
Lordship, my instructions are awaited, Your Lordship.
Awaited.
Yes, Your Lordship.
So say that. Why are you being so hesitant to say? This has come on the first time after issuance of notice. So you asked.
Notice was issued in the year of 2023, March.
You are, at least, this is just 1 year. You have seen there are cases of 2018 where till date no instruction has come.
Lordship.
This is the first time that this matter has been listed.
Lordship.
Yes. As prayed for by MS.N. Bordoloi, Learned Standing Council, Revenue.
Yes, Your Lordship.
Revenue Department. Are you going to file something?
No,
You will file, right?
Lordship, yes, Your Lordship.
Which is not opposed by the other side. List this matter after 2 weeks to enable the respondent to file their return in the matter.
25.
Rejoinders have not been filed?
My lord, almost pleading is completed.
Pleading is completed. It seems only affidavits have been filed by R5 and R2.
My lord, I love to draw your lordship can attend only 2 orders passed by the...
You are the respondent.
5, my lord.
1 second. Yes.
Lordship, my case is that I had purchased one Bisleri 20-liter jar.
You have purchased what?
Bisleri water of 20-liter jar.
Bisleri water?
Yes.
Yes.
And after taking the jar at my home, I noticed some foreign particles or alien particles inside the jar. Then I made a complaint to the manufacturer. As per the rule, the manufacturer will have to collect the sample from my home. But when they did not collect the sample, I have submitted the jar to the designated food and safety officer with the request to send it for analysis to the state laboratory. And analysis was done. The report is on page number 34.
Page 30?
34. Sorry, Lordship, sir. Sorry.
Yes, yes.
It is
no
not
problem.
34.
Page?
I am trying to find out what's it. Page number 33.
33?
33 of my petition.
33 is a report.
Yes, analysis report. And this report confirms that this opinion I may be allowed to read out, Lordship. The sample showed presence of some foreign substance, namely dead fly and few suspended fibers inside, resulting out of the inappropriate processing, and the sample cannot be regarded as clean and wholesome as required by the food safety and standard regulations. Hence, the sample has potential deleterious effect on the human health if consumed and is unsafe according to the section 3 of within bracket 1 within bracket ZZ of the Food and Safety and Standard Act 2006.
Yes.
So this is the report. So as per the report, the authority will have to take action against the manufacturer. And the penal provision says that they are to issue notice to the manufacturer, and if asking him to rectify the defect.
And you are the shopkeeper?
No.
Who are you? You are the purchaser?
Purchaser.
You are challenging this report?
No.
What are
I
you
am not challenging the report.
You are seeking a direction to the respondents to take action against the manufacturer?
Yes, Lordship.
That is what you are asking?
Yes, Lordship. And that has not been done. That is why this writ petition.
How are you aggrieved? Mr. Counsel, how are you aggrieved?
Yes. Because the Act says that when a complaint is made to the authority, then they are to follow the procedure on my complaint. And this
According to you, they have not performed the duty as required under the statute.
Yes.
And that is why you have come under Article 226.
This is my legal right, that on my complaint they will have to act according to the Act.
Where is that part?
Today I don't have the book, Lordship.
You see, this code is investing time, and then you are not prepared, you are not having the relevant act. You must come with the relevant acts. As prayed for list next week.
27.
Yes, Mr. Roy?
Response is yet to come.
Returns not filed?
No, not filed.
Yes. First time this is listed after notice.
Yes, ma'am.
Yes, Mr. Gogoi.
Lordship, we would like to file an affidavit.
As prayed for by Mr. R.R. Gogoi, Learned Standing Council.
Standing Council, Excise.
Forest, Excise.
Excise.
Learned Standing Council, Excise Department seeks 2 weeks time to file return in the matter. Prayer is not opposed. List after 2 weeks on a date to be fixed by the registry. Superb, J. Roy, assisted by
B. Shaha.
Did you put an appearance too?
Oblige.
29.
The petitioner has then was died Tito on 30/6/2019.
Only R4 has filed return.
Lordship.
Yes.
On behalf of APDCL, no affidavit filed, Lordship.
This is what?
What the stand of the government inspect.
It's an electrocution.
Yes, sir.
Electrocution death.
Electrocution,
You are for APDCL?
FADCL also.
What about the electrical inspector's report?
We have filed an affidavit. So this affidavit reflects the inspection report has been annexed. So here it shows it's a double responsibility. It is a misdeed upon by the petitioner as well as the FPDCL. So the report, the last part of the report is page 76.
Yes.
So the petitioner, the claimant was doing some unauthorized maintenance. That apart, there has been some violation on the part of the FPDCL also. That has been reflected. So if your lordship goes to clause 12, causes leading to the accident. From
you have received your instruction?
No, Lordship, I received the instruction, but I have to examine the report, Lordship.
So then we will give you the time. In the meantime, you verify and as prayed for by Mr. J.K. Goswami, Learned Standing Council, APDCL, list this matter after 2 weeks on a date to be fixed by the registry to enable the APDCL to verify the contents of the affidavit filed by the state government pertaining to the inquiry held by the Chief Electrical Inspector.
Lordship, a copy of the affidavit is necessary.
Serve him.
You can definitely take it.
All right.
Obliged, man.
None appears for the petitioner when the matter is called. Stop. Mr.
D. Bora.
Mr. D. Bora, Learned Counsel for respondent number
4.
4 is present. List this matter on Friday on such and such date with remark for dismissal.
31.
BTC is the main party.
BTC?
BTC is to reply.
Where is BTC? Can you please ask for Miss Bora? Wait for some time.
32.
32, Lordship. Similar matter, Lordship.
Similar matter?
Yes, Lordship. And again, writ petition number 2931, Lordship. The order has already been passed, Lordship.
You mean to say this? There is already this is covered by an order passed by this court.
Yes, yes.
Where is that order? You are not having it today.
No, Lordship.
Why? Why are you not prepared? It is to your advantage.
Yes, Lordship.
Then
Let a copy be served upon us also, Malad, fix another date.
you indicate that order to Ms. Das. Your name?
A. Dekha, Lordship.
Mr. A. Dekha, Learned Counsel for the petitioner, submits that the issue involved in the present writ petition has already been dealt by this court in another writ proceeding. Stop. However, today when the matter is called, he submits that he is yet to collect the order. He submits that he does not have a copy of the said order. Stop. List on such and such date.
33.
Security arrangements.
Lordship.
Yes, what has happened?
Lordship, my...
Is there some threat?
Lordship? Lordship, as per last order, Lordship...
Returns not filed.
Not filed, Malad. I have not received the
Why?
instruction.
Returns are not filed in any of these matters.
Malad, it's in the month of December, Malad, letters. And anyway, Malad, I'll try to file it.
MS Yudas, Learned Additional Senior Government Advocate, seeks 2 weeks' time to file return in the matter. Prayer is not opposed. List after 2 weeks on a date to be fixed by the registry.
34.
Last occasion, the Lordship is to give the liberty to file in this case for IA for impleading.
Have you filed?
That was filed on today, man.
You filed today?
IA number 8105.
All right. Mr. N. Bora, Learned Counsel for the petitioner, submits that the interlocutory application for
Implement.
for implement has been filed today.
My lord.
Stop. However, the same is not on record.
My lord.
Let registry verify and list the same
My lord.
next week, on
I
any
know-
date next week.
I number is there, madam. IA
That
civil
is-
8105.
1 second, Doctor. Jut koisa IA bili tate koa being IA number
IA civil 8105.
8105.
Probably 2020. Mark. 35.
Mr. Bora, is that a filing number or the IA number?
Filing number.
That's filing. Viday filing number. Yes. Returns.
Timing, madam.
What about returns?
Look,
Hey, Mr. Bucha, orders have already been passed in your matter. We have given another date. You please take the date from the court master.
Lordship, we might need some time to obtain our instructions regarding the new affidavit which has been filed by the repetitioner.
You are?
Lordship, I am M. Bhuya on
as prayed for by Mr. M. Bhuya, Learned Counsel for respondent number
4 and 5, Lordship.
4 and 5, comma, list this matter after
2 weeks, Lordship.
After 2 weeks to enable the respondent to obtain instruction
regarding the affidavit which has been filed.
To obtain instruction with regard to the affidavit filed by the petitioner on 24/6/2024.
Lordship. Lordship, Lordship.
Supplementary admission 52 and 53.
Wait, please, Your Lordship. Item number 52 relates to my grievance of non-renewal of the licenses of my pharmacist license, and there was a direction by this honorable court not to take any coercive action against me without affording an opportunity to hearing. Now, in spite of that, they have cancelled my licenses. So the next case is challenging the impugned action on their part to cancel the licenses, and there is a stay operating in my favor.
Okay.
Lordship,
Returns not filed.
Lordship, regarding both the cases, we have received our parawise.
So you filed it.
Lordship, we'll file it.
Your name?
M. Bhuya, Lordship.
Mr.
M. Bhuya.
Mr. M. Bhuya, Learned.
This is for.
You are appearing as standing counsel?
No, Lordship.
Learned counsel for the respondent number?
All the respondents.
For the respondent submits 2 weeks time, submits that he has received the parawise comment in the matters and accordingly seeks 2 weeks time to place the same by way of an affidavit. Prayer is not opposed. List the matter after 2 weeks on a date to be fixed by the registry.
Your Lordship, there is an interim prayer.
Interim, if any, shall continue till the next date of listing.
Deeply obliged.
Much obliged.
52, 53, right, Mr. Singha?
Yes, Your Lordship. The interim order is in only 53.
I'm giving a combined order, actually a common order that did interim, if any. All right.
Deeply obliged, Your Lordship.
38 for orders.
May it please, Lordship? Lordship, Respondent 1 and 2 has supposed to file their affidavit, but as per Office Note 25/9/19, there is no affidavit has been found.
Is it?
As per Office Note 25/09/19.
25?
09/2019.
Yes. No affidavit has been received by the section till date.
Lordship. Oh, it's a whole pending matter. Lordship.
That's true, but a specific submission has been made on 4/9/2019 that an affidavit in opposition was filed on 14/6/19.
Lordship.
Now the registry has verified way back on 25/9/19, as well as there is another subsequent noting which has been rightly pointed out by the petitioner.
Lordship, already been submitted affidavit of
No, you see, I don't think
it was not in record, Lordship.
I don't think
Lordship.
This will serve any purpose to anyone. You do one thing, you refile the affidavit.
Lordship.
Have you received a copy?
Yes.
You had been served out a copy.
Yes.
All right, you refile that affidavit then,
Lordship.
because it appears that something has gone wrong,
Lordship.
right?
Lordship.
And you refile it. How much time you need it?
2 weeks, Lordship.
2 weeks for refiling. 1 week.
Lordship.
Refile it because the whole matter.
Lordship.
It appears that though it was submitted on 4/9/2019, that an affidavit in opposition was filed by the respondent numbers 1 and 2, on 14/6/2019, but the same was not available on record. Stop. But since the same was not available on record, comma, this court directed the registry to verify the same. Stop. It appears from the office note dated 25/9/19 and 2/7/2004 that no such affidavit has been received by the section till date. Stop. However, MS
D. Pathak.
D. Pathak fairly submits that a copy of the said affidavit in opposition was furnished to them at that time. Stop. Be it as it may, let the respondent refile the affidavit in opposition within a period of 2 weeks from today. List this matter after 2 weeks of the date on such and such date. All right?
Wait, please, Your Lordship. Lordship may peruse the order dated 25/6/2024.
Order dated?
25/6/24, Your Lordship.
25/6/2024,
Your Lordship.
There is no such order.
It is the Lawajima order, Your Lordship. Lordship,
yes.
As per the said order, Your Lordship,
yes.
The notice has been served upon respondent number 4, Your Lordship.
So R5 is complete.
Yes, deemed to be complete, Your
Yes.
Lordship. Deemed served.
It appears from the office note dated 25/6/2024 that service in respect of R5 stands completed. Stop. Yes, who's appearing? Anybody appearing?
My lord, I am for the government, my lord, Deputy Commissioner, my lord.
You filed your affidavit.
Yes, my lord, we have filed. My lord.
You want to file any return?
Lordship, pleadings are complete, I think. Lordship, it may come up for admission, Your Lordship. Pleadings are complete.
List this matter for admission on any date next week by the registry.
Obliged.
List this matter next week on a date to be fixed by the registry.
Anything survive or not?
I'm appearing for respondent number 8, 9 and 10, my lord. I'm appearing for respondent number 8, 9 and 10.
Where is the petitioner? No one is appearing for petitioner. None appears for the petitioner when the matter is called. List this matter, Friday dated here, with remark for dismissal.
41.
None appears for the petitioner when the matter is called. Stop. Are you appearing, Ms. MSU Bora, learned additional, MSU Das, learned additional senior government advocate, is present for the respondent, state respondent. Stop. It appears that on 26/8/2019, when the matter was last called, there was also no representation on behalf of the petitioner. Stop. In view of the consecutive non-representation of the petitioner, this petition stands dismissed for non-prosecution. Disposed of. It took him on 41.
42.
Dear my lord, it is daily basis. It has now been, my lord, withdrawn by the government, my lord. My lord, this honorable court has already, my lord, considered all the matters, my lord, together regarding daily basis on the fishery on daily basis, my lord. Dibrugarh Fishery Cooperative Society, no, my lord.
42. This is a land acquisition compensation, correct?
Yes, my lord.
42.
My lord, wrong file has come.
As prayed by the petitioner council, last time there was a...
My lord, we have filed an additional affidavit, my lord. To show one thing, my lord.
You filed an affidavit in reply?
Yes, yes, no. Reply affidavit we have filed.
Alright.
My lord, what happened is that, my lord, the petitioner was having a land. But the land was acquired. But he did not receive any compensation. So he filed a writ petition, and thereafter this honorable court directed that his matter may be considered. But his matter was not considered by the respondent already, saying that he is not entitled to receive any compensation, as because there is certain case. So, my lord,
As
when
re-
there is
why you are not entitled for compensation? Because
there is certain case.
What case?
That is why that is why I'm telling. That thereafter, my lord, they filed a affidavit in reply, my lord, affidavit in opposition. In the affidavit in opposition, they have mentioned about a certain case by which my mutation was cancelled. So,
in the sense that they are saying that your possession is disputed.
Yes, my lord.
Yes.
My ownership also is disputed.
Ownership is disputed.
Then, my lord, the order by which the mutation was cancelled, I preferred an RTI application, my lord. But they could not furnish me the information, my lord. So in the affidavit in reply, my lord, we have annexed this document, my lord. They could not submit me anything, my lord. They have said that it is not found, my lord. In page, my lord, 69 of my affidavit in reply, my lord.
Today you have filed this affidavit.
No, not some days before, my lord. In the month of May, I think.
All right, 60.
Page number, my lord, 69. Affidavit in reply, my lord.
There is no 69.
My affidavit, no, it is not in the read petition, my lord.
I know.
60 maybe 60.
I have your affidavit in reply.
60.
The affidavit in reply you are referring is the one which has been filed on 22nd May. 60. Yes. What is the date?
My date is 16/9/2022.
Yes.
During the pendency of
Is not found.
Not found. They said that it is not found.
Where is the questions? The RTI that you sought. Kindly furnish a copy
My
of
lord,
the order.
Page number 58, my lord.
Yes. Now, on what basis then you have made this averment in the affidavit, Ms. Das?
My lord, in that case, I need a short accommodation, my lord, so that I can take instruction, my lord. On what
Because
basis,
your
my lord?
RTI information says no order found. If
but
there is
my
no
lord-
order, how can you take that stand in your affidavit?
Sita mutation was also rejected, my lord, as per this case. So, record, my lord.
You find out because
My lord.
otherwise, you see, on oath statements are being made.
My lord.
And if
There must be some basis
there
on
has to
that.
be some materials,
Right.
otherwise on what basis such statements have been
Has
made?
been made,
And at the you see what is stake is is much high because the constitutional statutory human right of the petitioner is at stake. It is his right to the property,
Lordship.
isn't it?
Lordship.
It cannot be dealt so mechanically. All
My
right.
lord. My lord.
You take instructions.
My lord. 42, तुम्हारा number तो दिया ना? तुम्हारा number तो पूछा तुम दौड़
Mr. I. Chaudhary, Learned Counsel for the petitioner submits that though the state government in their affidavit in opposition has taken a stand that the ownership of the petitioner is doubtful over the subject acquired land, comma, for which the compensation sought for has not been released till date to the petitioner, comma. However, while seeking information as regards the order on miscellaneous application number 1146-7/10/2009 and subsequent order on Ha/Da case number 245/2009-10 dated 13/11/2009, comma, page 60, comma, the Circle Officer, North Guwahati Revenue Circle, Amingao, by letter dated 16/9/2022, replied that the document sought under RTI is not available, is not found. Stop. That being so, let MSU Das obtain specific instructions as regards the same and place the same on the next date of listing.
Lordship.
List again on such and such date.
The 3 weeks, my lord. 3 weeks. Okay. 9th August.
44.
May I please your lordship?
Returns not filed.
Lordship, I am appearing from the Trichyia Municipal Board recently engaged, Lordship. We will file. Most probably, my Lord, matter become infructuous.
Lordship, my senior is his
Then let me have the instruction, Lordship.
As prayed for by Mr. S.S. Roy, Learned Standing Council, Tinsukia Municipal Board, list this matter after 2 weeks to enable the said respondent to file their return in the matter.
Lordship.
In this case, my lord, may I pray for Monday? I am not well today, my lord. Maybe on Monday I pray.
It appears that this matter was listed today. No. 1 second. What is your prayer? I'm sorry, I didn't follow.
My lord.
Prayer is this. You are not well today.
First floor building. Prayer for construction of first floor today building.
Mr. Counsel,
you are
not feeling well today?
Maybe on Monday, my lord.
All right. It is submitted that it is submitted by Mr. SKSN Muhammad, Learned Counsel, for the petitioner that he is not feeling well today and accordingly seek some accommodation of the matter. Prayer is allowed. List this matter on Monday. Tuesday. I am fixing it on Tuesday, not Monday. Wednesday.
Lordship, may I pray, Lordship? In this matter, I have already received my instruction.
Then you file an affidavit?
If time is granted to me, Lordship.
Mr. As prayed for by Mr. P. Nayak, Learned Standing Council, GMC, list this matter after 2 weeks and a date to be fixed by the registry to enable the said respondent to file their return in the matter. In view, none appears for the petitioner when the matter is called.
My lord, I am appearing on behalf of B. Chaudhary.
Heard Mr.
H. Borwa.
H. Borwa, Learned Counsel, appearing on behalf of
Mr. B. Chaudhary.
Mr. B. Chaudhary, Learned Standing Counsel, Finance Department. Anybody else?
Finance and Taxation, my lord.
Finance and Taxation. Stop. It appears that since there was no representation on behalf of the petitioner when the matter was last called, i.e. 27/6/2024, this matter was listed today with the remark for dismissal. Stop. However, today when the matter is called, there is also no representation. In view of consecutive non-representation on behalf of the petitioner, this writ petition stands dismissed dismissed for non-prosecution.
Highly obliged.
47.
Disposed of. Yes, PHE department.
Yes, Your Lordship. Awaiting instruction, Your Lordship.
Awaiting instruction.
Yes, Your Lordship.
As prayed for by Mr. R.R. Gogoi, Learned Counsel, for the Learned Standing Counsel for PHE department, list this matter after 2 weeks to enable the respondent to file their return in the matter.
All right.
May it please, Your Lordship.
Contempt.
My Lord, will kindly come to page number 19, my Lord.
Yes.
Para 9.
Yes.
In view of above, and without expressing any opinion on the merits of the claims and counterclaims of the parties, and as agreed to by the Learned Counsel for both the sides, both these writ petitions are being disposed of by granting 10 weeks time from today to the respondent number 4, that is Joint Secretary, Department of Revenue, KAAC DIFU, to pass appropriate order on the application dated so-and-so submitted by the petitioner in WPC number so-and-so for mutation. Before passing any order, objection filed by the respondent number 8 and 10 shall also be taken note of. It is made clear that it would be open for the concerned authority to pass appropriate order on application seeking mutation based on materials available on record on the date of passing order. My Lord, this is an order of 21/8/23, and today we are almost 1 year. My Lord, what had happened in this case, the petitioner has lost her husband, petitioner has lost 2 of her sons under mysterious circumstances. There is a fight between 2 groups for ownership of a tea garden. Now this KAC authority are blatantly siding with the respondent, my Lord. My Lord, is it not duty of my learned friend to get the instruction in a contempt matter? Kindly see me, Lord.
Nothing has been filed.
Nothing has been filed. And what is to be filed? They have to pass an order on my mutation application.
Yes,
they
Mr.
have
Chutiam,
disrespect for this authority of this honorable
Chaudhary,
court.
just a minute.
Yes.
Mr. Chutiam,
My
why no affidavit has been filed, and it appears that the order of this court has also been not complied till
order
date?
has been complied with, order has been passed, my lord.
No,
Lordship,
if the
granted-
order has been complied, then you see the petitioner
My
will
lord,
not be
yesterday,
before
my
this
lord,
court,
my lord, yesterday,
wasting
my lord,
their time.
my lord, yesterday, my lord, the first date anniversary of the joint secretary is there. So I informed the other side that I could not file the affidavit. And from the 26th, my lord, there is some training program is there. Lordship will fix any other date.
Mr.
We'll file
Chutia,
the
this
affidavit.
court is not concerned about the itinerary of your department.
My lord.
This court is only concerned whether the order of this court has been complied or not complied.
My lord.
This matter has been filed way back.
My lord.
But no explanation has come till now whether it has been complied, and if not complied, why it has not been complied. Nothing has been filed till date.
Grant me 1 week time, my
This is
lord.
the last chance
my
this
lord.
court
Last
is going to
chance.
give. Otherwise,
Last chance. Otherwise, Lordship will
personal
direct the
appearance may be
respondent
directed.
to personal appearance of the respondent,
Yes,
my lord. Last
because this cannot go on like
my lord.
this.
Last chance.
There is a specific direction of this court which appears to
My
have not been
My
complied
lord,
till
order has
date.
been passed. I will, my lord, annex the order of the passed by the my lord respondent in the affidavit, my lord, within 7 days, my lord.
Mr. J. Chutia, learned standing counsel. You're appearing as a standing counsel here?
My lord, for the respondent,
For
my
the,
lord.
for the contemnus submits that an order has been issued complying the order passed earlier by this court on
21/8/23.
21/8/2023. However, the same is not available with him today when the matter was called. List this matter on next week, give a date.
My lord, on Wednesday.
On
my lord, Friday, my lord.
All right, Friday. On such and such date, to enable Mr. So and so to place the said compliance or to place the said order before this court. Stop. It is needless to clarify, failing placing the aforesaid order and or any affidavit, orders including personal appearance of the contemners, if required, shall be passed on the next date of listing.
Deeply.
Time being added 20.
May I please your lordship? Lordship, my senior Mrs. Egan is not available today. Matter
Huh?
may be fixed. My senior Mrs. Egan is not available today for some personal.
That's all right. You see, why the matter was kept for the time being is because it appears that no returns have been filed.
Lordship.
So all that this court wants to know is how much is number one, are you going to file any affidavit?
Lordship,
And if you're going to file an affidavit, how much time do you need?
Lordship, 2 weeks time.
So I will record that, and in the meantime you file whatever is to be filed,
Lordship.
because these matters cannot be kept hanging like this. Substantial right of the petitioners are at stake.
Lordship.
All right? Yes. As prayed for by MS
M. Borman
M. Borman on behalf
of Mrs.
of
Egan.
MS A. Gayan, Learned Counsel, appearing on behalf of respondent number,
Lordship, CCC.
respondent CGC, comma, list this matter after
1, 2 and
list
3,
this
Lordship.
matter on any date. List this matter after 2 weeks on any date fixed by the registry for enabling the said respondent to file their return in the matter.
Earlier stay order, Lordship.
Interim order
Yes, yes.
is there, if any, shall continue till the next date of listing. Are you asking now?
Time being 31.
Yes. Mr. Nayak, no returns.
Lordship, instruction awaiting, Lordship.
Instructions awaiting.
Yes.
Mr. P. Nayak, Learned Counsel, for the respondent submits that the instructions are 2 weeks time to file their return in the matter. Prayer allowed, list after 2 weeks and a date to be fixed by the registry.
My lord, interim.
Interim, if any, shall continue till the next date of listing.
Supplementary August 54.
in this present PS case, my lord, FIR has already been, my lord, submitted, my lord.
On the last occasion also there was no representation on behalf of the petitioner.
Lordship.
None appears for the petitioner when the matter is called. Stop. It appears that heard MS U Das, the additional senior government advocate for the state respondent. Stop. It appears that on 17/7/2024, when the matter was last called, there was also no representation on behalf of the petitioner. Stop. In view of the consecutive non-appearance on behalf of the petitioner, this writ petition is then dismissed for non-prosecution.
Lordship, oblige me.
55.
Disposed of. Yes. The contempt.
Yes, Lordship. Your Lordship wanted to know the consequence of...
Oh, it is that matter.
Yes, Lordship.
Yes.
Just to start with, what Lord Dunning had to say.
Yes, yes.
My learned friend will give it, Your Lordship.
Yes, please.
Let me say at once, we will never use this jurisdiction as a means to uphold our own dignity, nor we will use it to suppress those who speak against us. We do not fear criticism, nor do we repent it, for there is something far more important at stake. It is no less than the freedom of speech itself. It is the right of every man in Parliament or out of it, in press or over the broadcast, to make fair comment, even outspoken comment on matters of public interest. We must rely on our own conduct itself to be its own vindication. Then the origin of the law of contempt. Also the statement of objects and reasons I have put in there.
Yes.
Now come to the point of withdrawal. There is a case from Patna High Court. Your Lordship will get that.
Yes, Manoj Kumar.
Yes, Lordship.
Yes.
Manoj Kumar Jha versus the state of Bihar.
Yes.
92-1 PLJR 460.
Yes.
The very first paragraph deals with it. I am reading the second line. As the petitioner is a poor man and for some reason or others, in spite of a very serious situation having taken place in this case, for which he sought the relief from this court by way of filing a contempt petition, he has instructed Mr. Jha, that's his lawyer, to withdraw this application for contempt against the district magistrate concerned. However, Mr. Jha has pointed out that as an advocate of this court, he is an officer of the court and he has a duty to perform so far as the court is concerned. Accordingly, though he asked for leave to withdraw the formal application filed by the petitioner for contempt against the contemner respondent, he draws the attention of the court to the incident and requests the court had to proceed in contempt, and so the court had to proceed in contempt suo motu against the contemner respondent on the basis of the materials disclosed in the petition for contempt. We consider that this is a very fair and proper stand taken on the part of Mr. Jha. As a lawyer, he has to act on the instruction of his client, but as an officer of the court, he has a superior duty to protect the interest of the justice and the dignity and prestige of the court. Accordingly, we allow the formal application made by the petitioner to be withdrawn as not pressed, but however, on the basis of the allegations and averments disclosed in the pleadings, we initiate a contempt proceeding against the respondent number 2, suo motu.
It can suo motu be, it can be taken up suo motu.
Yes,
if
Lordship.
the court, for that I think one has to come to see which is the order,
Yes, Lordship.
which is said to be not complied. Correct, Ms. Chaudhary? So where do I find that? Do you want another, there is another decision of Patna?
Yes, my lord. That's on the transfer of officers of the court. Also cannot be a ground to defeat this.
Where, which paragraph?
Para 29.
Yes, the transfer of officers can also be no ground to defeat its implementation.
Yes, madam.
And what is this Amrit Lahata's case? Supreme Court?
Dealt with withdrawal for taking action for contempt of court. And para 7, request for withdrawal of the proceeding initiated for taking action for contempt of the court. The court would generally be guided by broad facts of the case and more particularly whether respect for judicial process would be enhanced or dwindled by either granting or refusing the grant or the request.
This is exactly what was in the mind of the court.
Yes,
you see, the contempt is of the court and not of the individual.
Yes, contempt is of the court and not of the individual. Therefore, Section 15 of the Contempt of Courts Act confers powers on this court as well as the High Court to take suo motu action or on a motion made by, amongst others, the Solicitor General. It is for the court to determine whether the act complies of tending to scandalize the court if viewed with certain severity with a view to publishing the person would be in the larger interest of the society, and enhance punishing the person would be in the larger interest of society, enhance respect for judicial process, or too sensitive attitude in such matter may even become counterproductive. Para 7,
All right.
385 to 386.
I think that's sufficient. Let's go to the order which is said to have not been complied. Which is that order?
It's at page 9, order dated 22/9.
Page 9?
Yes, Lord. 2019.
Yes. 2019 order.
Yes, sir.
Operating part is the last para, having regard.
Yes,
the
my
Deputy Director of Food Civil Supplies and
To look
Consumer
into the
Bongaigaon
grievance of the petitioner
as
as
per
per application dated
so-and-so.
17/12/2018 and thereafter take appropriate decision in accordance with law.
Within a period of 30 days.
Yes, Lord.
That has not been done.
That has not been done.
And who are the respondents?
Only Habibur Rahman. In
In
charge.
charge.
Direct-
He has been transferred in
Yes,
the
sir.
meantime. But he will be an officer of the Food and Civil Supply.
Yes, my lord.
Ms. Das, is there a standing council? Yes, Mr. Das. You represent? No, I'm not asking for that. You see, Ms. Das, in this contempt petition, on the last occasion, there was a submission on behalf of the engaged counsel for the petitioner that since the new incumbent's address is not being able to be ascertained, and therefore they had instructions to withdraw. But this being a contempt matter, and since on that date no one had any information as what is to be done, this court requested the assistance of MS Chaudhary, and she had agreed, and this court appreciates the assistance that she has given today. Now it appears that this is between the court and the contemptor, because the non-compliance is something which is concerned with the court and not of the individual, correct?
Lordship.
Keeping that in mind, suppose this court takes this matter suo motu. Even in that case, the presence of the new incumbent is essential. Now, the registry will not be able to find out the address of the present incumbent. This court will require your assistance.
I can, my lord, because kun department or code. So, my lord, if she gives the
Yes, no, in fact, everything is there with court, so I shall direct the registry to give it.
Lordship,
Because you see, Miss Chaudhary is also before this court because the court requested her.
Lordship,
She is
only-
not a engaged counsel.
if I
so
can photocopy.
we will ask the court registry to give you the entire copies.
Lordship.
All right.
My lord.
All right. Anupam Venikala. Miss Chaudhary, you may take your seat.
My
Yes, please take your seats.
My lord.
Heard MS R. Begum, Learned Counsel for the petitioner. Stop. Also heard MS B. Chaudhary, Learned Amicus Curie. Stop. N ko also no ko ba N. Also heard MS. Okay, stop. This is an application under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Courts Act 1971 and Contempt of Courts within bracket Guwahati High Court Rules 1977 for initiating contempt proceedings against the contemner for willful alleged violation of of this court's order dated 22/2/2019 passed in WPC number 1165/2019. Stop. It appears that since the sole respondent during the pendency of the contempt proceedings has been transferred, from the post, the petitioner the petitioner requested accommodation to take steps for impleading the new incumbent. Stop. However, the new incumbent is not arrayed However, no impleading application of the new incumbent has been filed till date. Stop. On the last occasion, i. 15/7/2024, when the matter was last called, Ms. R. Begum, Learned Counsel for the petitioner, submitted that she has been instructed by the petitioner to withdraw the contempt petition as the address of the new incumbent could not be asserted. Stop. At that stage, this court requested MS B. Chaudhary, Learned Counsel, who was present in the court, to assist the court in this regard. Stop. Today, when the matter was called, MS B. Chaudhary, Learned Counsel, by relying on the decision of the Apex Court reported in decision of the Apex Court in the case of Amrit Nahata versus Union of India, reported in 1985 volume 3 SSC at page 382, submitted that the role of the petitioner after filing the contempt petition comes to an end, and thereafter it is between the court and the contemner. Stop. She further submits that since the order of this court passed on 2019, which is the date 22/2/19 in WPC 1165/2019, appears to have not been complied till date, the present petition can be converted, can be taken up suo motu by this court under the powers contained in the Contempt Act, so and so. Stop. Paragraph 7 of the aforesaid decision is reproduced hereunder for ready reference. Stop. It appears that by order dated 22/2/2019, this court directed the Deputy Director of Food Civil Supplies and Consumer Affairs Bongaigaon to look into the grievance of the petitioner as per application dated 17/12/2018 and thereafter take appropriate decision within a period of 30 days from the date of receipt of a certified copy of this order in accordance with law, with due intimation to the petitioner. Stop. Despite the unambiguous order passed by this court, way back on 22/2/2019, the said exercise has not been undertaken by the Deputy Director of Food Civil Supplies and Consumer Affairs. Stop. The aforesaid non-action of the respondent appears to be contemptuous and is still perpetuating. Stop. Considering so, the contempt petition cannot be allowed to be withdrawn. Considering so, this court is of the considered view that the contempt petition can be converted into a suo motu contempt and accordingly does so. Stop. The petitioner is excused from the aforesaid case. Registry is directed to re-register the case as a suo motu contempt case. Stop. Further, keeping in mind that the details of the new incumbent of the said post is not available in the records of the case, this court requests MS U Das, learned additional senior government advocate, State of Assam, to give the details of the new incumbent to the subject post to the registry of this court, whereupon notice shall be issued to the new incumbent through the office of the registry. So, list this matter after 2 weeks, after 3 weeks on a date so and so, and this court appreciates the assistance rendered by MSB Chaudhary, learned amicus curiae, and she is excused hereafter. That's all. I don't think anything else. It has to be re-registered.
My lord, as and when, my lord, I'll get the copy, my lord,
You let a copy of the entire case be furnished to MS U Das, learned additional senior government advocate, by the registry of this court to do the needful.
Lordship,
56.
Ms. Chaudhary, I am keeping these documents.
Just read a court my lord, here I can appear, my lord.
In 56?
56.
56 is also a content.
No, my lord, this is my lord.
There is an office note dated 29/6/2024.
Lordship asked me to take instruction whether I can appear for respondent number 5. I can appear, my lord.
Ms. U Das, learned additional senior government advocate, submits that she has received instructions to appear on behalf of respondent number 5 and accordingly seeks some accommodation in the matter to file necessary
affidavit on behalf of 5 and 6, my lord. Both.
It's filed.
My lord, not filed. I pray for time.
Correct. That's what I'm recording. To file affidavit in opposition in respect of respondent number 5 and 6. Stop.
Lordship.
Prayer is allowed. List after 2 weeks, after 3 weeks, or a date to be fixed by the registry.
Obliged, madam.
Obliged.
Order hearing item 57.
This is that matter. Mr. Chaudhary is also appearing in this matter?
No, my lord. My lord, actually I am appearing in item number 49, my lord.
There
40?
are 49. They were supposed to produce some records, my lord.
Updated status of the case record, Lordship, we have not received. I pray for some time, Lordship.
49.
49, Lordship.
Yasin, file in 49, Anupam, just take down. Mr. S.S. Roy, learned government advocate for the state respondent, submits that the records as sought for by this court is still awaited and accordingly seeks accommodation in the matter. Prayer is not opposed. List after 3 weeks. List after 3 weeks on a date to be fixed by the registrar. It's a 2013 matter.
Can there be a fixed date, my lord?
I'm giving a fixed date. List on such and such date. All right.
I'm deeply obliged.
Yes.
My appearance will be recorded, my lord.
Didiba, Mr. B. Chaudhary and S.S. Roy. Yes, Mr. Sahewala, I think you have already...
I have
yes,
good, my lord. The same has been quoted in the judgment also. Same.
I have seen. Independent, because it appears from the materials available that he was accompanied by officers of the state.
Yes.
Now, can that be said to be independent witnesses? Because the decision of the Apex Court is very clear. You see, in that 74 decision, at paragraph 4, it is very clearly said, we are of the opinion... We are of the opinion, particularly in view of the legislative history of section 10(7), that while taking action under any of the provisions mentioned in the subsection, the food inspector must call one or more independent persons to present at the time when such action is taken. So what is required is to call. Now whether after the calling one independent witness comes, doesn't come, that is different. But one must make an endeavor, mandatorily make an endeavor to call. This is the legislative intent, correct? And in this case, which the Supreme Court was dealing, there the Supreme Court, however, did not agree with the general proposition that regardless of the circumstances, the non-presence of one or more independent persons at the relevant time would vitiate the proceeding. This observation was done because in this case, there was the authorities tried to call the person from the neighborhood, but nobody came. Now, in that situation, obviously, if nobody is coming, how can that vitiate? So the requirement is to call. Admittedly, there is nothing, no whisper to show that that was done. On the contrary, it appears that the officer concerned was accompanied by officers of the state, police personnel and the food civil supply. Correct? That is the only thing. So that this court doesn't find that there was any endeavor for calling independent persons in that case, because these are not independent persons. Can they be said to be independent persons?
No, but I only, in my humble submission, Lordship, I want to state that, Lordship, I have one citation, though it is not related to Food Adulteration Act, but in this citation, Lordship, it is stated that, Lordship, police officers should not be approached with initial distrust, Lordship. So it just being a state official's Lordship.
Mr. Das,
Lordship.
Mr. Das, right?
Yes.
Mr. Das, that is in the facts of what? Is it in the case of an investigation?
Lordship, seizure and recovery. Search and recovery, Lordship. This case
that is not, but that is not under the statutory act.
Moreover,
Mukhtar Ahmed has not been examined by witness, madam.
Mr. Das, I don't think that decision has any relevance, because here it is not the question of initially whether police officers are taken to be with suspicion or not. That is not the issue. The issue in this case is very simple. The mandate of the law is that an endeavor has to be made to call independent witness. That's all.
But
now, you are trying to say that here he was accompanied by officers of other departments. But nonetheless, these officers are officers of the state how can these officers be said to be independent witnesses?
Moreover,
What is independent witnesses? Independent
not
witnesses.
interested, Lordship.
Exactly. And so independent witnesses would mean someone from the locality or from somewhere else who has nothing to do with either side.
Lordship.
Now here, the officers are of state.
But
maybe another department, maybe police official, but they are state officers.
It is.
How can you say they are independent? The word is independent, which is used in the Supreme Court decision.
But in this present case, Lordship, if it is to be so, Lordship, then the whole department will be against him, Lordship. Because the joint director is also there, then the deputy director is also present, Lordship.
This is
Whole
that you're not
department will be
following the query of this court.
I understand, Lordship.
That officer could have called someone independent, someone not connected with the case. There are other people around. There are other shops. There are shops or not other shops. Then he could have called someone from the other shops. Right, Mr. Sahewala?
Yes, my lord.
There were other shops in the neighborhood.
Yes, shops are there, my lord.
Yes.
Nagaon is the city, Nagaon town.
Correct. He could never said then. He could have called. Whether one comes or not comes, that is different.
Those two persons accompanied him, my lord, food inspector. So how can they can be?
That is the only thing. So I think, I'm sorry, but I don't think these two persons qualified to be independent.
Not my lord.
I'll pass the order now only.
My lord.
Right.
My lord, it's a lawsuit function, I leave, my
Yes,
lord.
yes, please. You. Heard Mr. G.N. Sahewala, Leonard Senior Counsel, assisted by
K. Sharma.
M.S.K. Sharma, S.A.R.M.A.
S.A.R.
S.A.R.M.A. M.S. So-and-so, Leonard Counsel for the petitioner. Stop. Also heard Mr. K.K. Das, Leonard APP for the state respondent. Stop. This revision petition has been filed under section 397, read with section 401 of the Code of Criminal Procedure, Code 1973, assailing the judgment and order dated 3/7/2013, passed by the learned Additional Session Judge Nagaon in Criminal Appeal number 2 within bracket capital N stroke 2011, dismissing the appeal, upholding the judgment and order passed by the Chief Judicial Magistrate in CR case number 3531 of 2008. Stop. CR 3531/2008, convicting the petitioner under section 7/16 of the Prevention of Food Adulteration Act 1954 and sentencing him to suffer a rigorous imprisonment for 6 months and to pay a fine of ₹1,000. Stop. The facts of the case are as follows. The opposite party, the respondent number 2, I, Inspector Food and Civil Supplies, Nagaon, filed an offence report dated 22/12/2008 before the Chief Judicial Magistrate, Nagaon, stating inter alia that on 2011-2008 he carried out a combined raid at MS Assam Oil and Atta Mill situated at SS Road, Haiborgaon, Nagaon, in response to a direction from the Joint Director Health Services, Nagaon, regarding a reported case of adulteration, and a number of police personnel, including the officer in charge Sodar Police Station, were with him, and after inspecting the mill and stock of mustard oil kept in sanitary condition in open drums, and collected sample from the stock of mustard oil kept in sanitary condition in open drums for analysis. Stop. It is the thereafter he requested MD Mukhtar Ahmed, SI Haiborgaon TOP, and MD Fakhrul Islam, Inspector, to remain as witnesses, and thereafter he took two samples, one from a seal tin and another from open drum, and the samples were packed in accordance with law and sent to the public analyzed, and on receipt of the public analyzed regarding adulteration of the samples, he obtained the sanction of the authority concerned and thereafter filed an offence report, on the basis of which CR case number 3531 of 2008 was registered. Stop. Thereafter, the Chief Judicial Magistrate, upon receipt of the aforesaid thereafter trial commenced. Charges under section 7/16 of the Prevention of Food Adulteration Act was framed, and trial commenced, and after conclusion of the trial, an examination of the witnesses, the learned Chief Judicial Magistrate Nagaon, by judgment dated 22/12/2010, convicted the petitioner under section 7/16 of the PFA Act and sentenced the same to suffer RI for 6 months with fine of ₹1,000. Stop. Aggrieved by the said judgment, the petitioner preferred an appeal before the learned Session Judge Nagaon, which was registered as Criminal Appeal number 2/N/2011. Stop. The said thereafter the aforesaid appeal was heard, and the appellate court, by judgment and order dated 3/7/2013, dismissed the appeal filed by the petitioner. Stop. Aggrieved by the aforesaid orders, the present revision petition has been filed. Next para. Mr. G.N. Sahaiwala, learned Senior Counsel, submitted that under the provision of subsection 7 of section 10, it is mandatory for the food inspector to call for independent witness before taking any action under the provisions of section 10 of the Act. Stop. In support of the aforesaid submission, he cites the decision of the apex court in the case of Ramlabhaya versus Municipal Corporation of Delhi, reported in AIR 1974 Supreme Court at page 789, and the decision of this court in the case of the state of Assam versus Sri Sumarmal Jain, reported in 1990 volume 2 GLR at page 99. Stop. He further submits that it is evident from the evidence of the food inspector within bracket PW1 and Fakhrul Islam, inspector of the food and civil supplies within bracket PW2, that during inspection that after inspection PW1 requested one Mukhtar Ahmed, sub-inspector of police, Hybergaon TOP, and PW2, who is the inspector of FCS and Consumer Affairs Nagaon, to accompany him during inspection in the subject mill and to remain as witness while collecting, sampling and seizing. Stop. He accordingly submits that it is admitted that PW1 has not made any endeavor to call for independent witnesses despite such witnesses being available in the location, and accordingly non-compliance of such mandatory requirement has vitiated the trial. Stop. Anything?
No. No, no.
Next, Mr. K.K. Das, learned APP, state on the other hand submits that since the two persons who had accompanied the PW1 during inspection, being from the police, one being from the police department and other
food and supply,
and other from the Department of Food Civil Supply and Consumer Affairs, comma, are qualified to be independent witnesses, and accordingly he submits that subsection 7 of section 10 of the said Act stands fully compliant. I have heard the parties at length and perused the materials available on record. Stop. Section 10 of the said Act is reproduced hereunder for ready reference. Quote unquote. It appears that under section 7, under subsection 7 of section 10, when a food inspector conducts inspection and takes sample of any article of food into custody for analyzation, comma, he has to call one or more persons to be present at such time. Stop. The apex court in Ram Labhaya, in the case of Ram Labhaya, within bracket Supra, held that the person mentioned that held that one or more person mentioned in subsection 7 of section 10 must mean one or more independent persons. Stop. Paragraph 3 and paragraph 4 of the aforesaid judgment of the apex court is reproduced hereunder for ready reference. Stop. It further appears that this court in State of Assam versus Sri Sumarmal Jain within bracket Supra, while following the aforesaid decision of the apex court, reiterated that it is manifest, reiterated that it is clear that that subsection 7 of section 10 is mandatory insofar as it relates to the duty of the food inspector to call one or more independent persons to be present at the time of taking the sample, etc. Stop. Paragraph 8 of the aforesaid judgment is reproduced hereunder for ready reference. Stop. Next paragraph. In the present case, it appears that from the evidence of PW1 during examination stated that deposed that during inspection he observed that the stock of mustard oil was kept in insanitary condition in open drums, and upon suspicion of contamination as well as adulteration, he expressed his intention of collecting sample of mustard oil kept in open drums, collection of sample of such mustard oil, and accordingly he requested Mukhtar Ahmed, Sub-Inspector of Police, Hybergaon TOP, and MD F. Islam, Inspector of FCAs and Consumer Affairs, Nagaon, within bracket PW2, who accompanied him during such inspection in the mill, to remain as witness of sampling and seizure works. Stop. PW2 during examination stated that he went to the place of occurrence slight lately and that initially everybody together inspected the articles and thereafter seized the same, and the bottles were of plastic, and he does not remember how many samples were taken. He further deposed that he does not remember how samples were taken, and he further does not remember as to how the sample was first kept occasion. Stop. Muhammad Ahmed, Sub-Inspector of Police, Hybergaon TOP, who is said to be who is said to be one of the other witness for the subject sampling and seizure work, comma, was not examined by the prosecution. Stop. The appellate court upon appreciating the available evidence, came to a finding that there was no lapse committed by the PW1 at the time of taking the sample, and as such was of the view that the trial court has rightly held that no prejudice was caused to the petitioner while samples were taken by the PW1 within bracket food inspector. Stop. The trial will लिखला the last step. Next para. The perusal of the judgment of the trial court indicates that the trial court do you have 2004 GLT 206? Do you have the case 2004 3 GLT 206? It's an idea, na, please. 2004 volume 3 GLT 206. After break, did you Anupam? The trial court, after taking into the case of this court after taking into consideration the decision of this court in the case of Gulabchand Gupta versus State of Assam, reported in 2004 volume 3 GLT 206, held that the evidence of food inspector is not to be treated as the evidence of an accomplice, and the evidence of food inspector be treated on his own credit, and if found acceptable, there is no legal impediment on the part of the court to rely on the same. Stop. Accordingly, the trial court held that the prosecution has successfully established the offence against the accused beyond doubt. Stop. And thereafter convicted the accused for the offence under section 7 read with 1617 of the PFA Act. Stop. I shall last key लिखिला ठीक है सर হ'ব next paragraph. What transpires from the above is that there is no evidence whatsoever to show that the food inspector called for any independent witness before taking samples of the subject articles. Stop. In fact, it appears that it is the admitted position that the said food inspector was accompanied by one police officer who was not examined in the matter, and one inspector of FCS and Consumer Affairs Nagaon within bracket PW2. Stop. As held above, it is mandatory for the food inspector to call for independent witnesses before taking steps under section 10 of the Act, of the said Act. Stop. Though Mr. K.K. Das, Leonard APP, has argued before this court that the said two officers present along with the food inspector shows that the provision of subsection 7 of section 10 of the said Act is complied, comma, the same appears to be a fallacy inasmuch as the said two officers, being officers of the state government, cannot be said to be independent witnesses. Stop. In terms of the ratio of the decision of the apex court in the decision of, in the case of Ram Lavaya with bracket Supra and the decision of this court in the case of State of Assam Supra, comma, it is the mandate of subsection 7 of section 17 requires the food inspector to make an endeavor to call for independent witnesses. Stop. In the present case, the food inspector could have called the neighboring shopkeepers to witness the taking of the sample, but there is no materials whatsoever, but the materials available on record indicates that the food inspector did not do the same. Stop. Therefore, there is a gross contravention of the mandatory requirement of taking samples under subsection 7 of section 10. Stop. Since the very factum of taking the sample itself has been contravened by the food inspector, comma, the same being a mandatory requirement, comma, vitiates the entire proceedings. Stop. As such, the conviction order as well as the appellate court's order upholding the said conviction is totally erroneous, is manifestly erroneous and palpably illegal. Stop. Resultantly, the judgment and order dated 3/7/2013 passed by the Additional Session Judge Nagaon in Criminal Appeal number 2N-2011 and the judgment and order dated 22/12/2010 passed by the Chief Judicial Magistrate in CR case number 3531/2008 convicting the petitioner under section 7 and 16 of the Act are set aside and quashed. Is he on bail?
Can I make a call?
Find out, because otherwise that portion has to be added. If he is in jail, he has to be released. Did you? Oh, sorry. I wrote a book. Azat lekhi diba. Pertinent that in the case of Gulab Chand Prasad Gupta versus State of Assam, decided by this court, which is cited in 2004 volume 3 GLT at page 206, which was relied by the trial court, it appears that in that case there was evidence to show that the food inspector called some nearby persons of the locality to witness the taking of sample of the food article in question, but none of them agreed to become witness. Stop. It was stop. Therefore, the aforesaid decision is of no relevance to the petitioner, to the facts of the instant case. Stop. Yeah.
Your Lordship, he is on bail.
He is on bail. Then I think a direction that the bail bond shall stand discharged. Anything else to be given?
No.
Bail bonds, bail bonds executed shall accordingly stand discharged. That's all, nothing else?
Nothing.
Mr. Das,
No,
you are the APP?
No, nothing. Okay.
বেলেগক মাতা অনুপম
Friday, second half, madam. Friday, second half.
Sorry?
Friday, second half. Hearing matter.
Is there any bar for taking up a hearing matter on a Friday?
We were just discussing, madam.
Huh?
We were just
What is there
discussing.
to be discussed, Mr. Counsels?
No, madam.
It's a working day.
It's a working day.
Unless you have some other difficulties you may express, but whether it's a Friday or it's a Monday, I don't think it makes any difference. Unless there is something else. Yes. What is this matter?
Yes, madam. No, this case was filed against an order which has been passed with reference to Madam Lordship.
It is an eviction matter.
Madam, is like that, madam.
Like
Because
that? What do you
yes,
mean by
madam,
like that?
I'll explain,
Are you
madam.
prepared or you're not prepared, Mr. Counsel? Yes.
The issue is very small regarding madam, if a Lordship comes to case 16. 1-6, madam.
Yes.
A petition was filed under section 144 of the CRPC. Wherein the
144
of CRPC.
This is the petition under 144?
44, madam.
Yes.
This petition was filed by the present private respondent number 6.
Mr. Das, who are you representing?
Yes, my lord. Yes, my lord. I am for the respondent number 6, my lord. Here, my lord, the main case is that, my lord, he is possessing government land, my lord. It is under DAG number 299. And so far, our is concerned 448. Now, my lord, they used to disturb our position.
Their number is DAG number?
Yes. One second. Not just come.
You just referred the
My
DAG
lord,
number.
yes, my lord. Just, my lord,
all right.
296, page 47.
296, DAG number is in possession of the petitioner.
Yes, my lord.
And yours?
And so far I am concerned, my lord, mine is DAG number 448.
448.
Yes.
Yes.
Of village number 2, Suktaguri, under Sipazar district, Dorong.
Yes.
Now, my lord, thing is that, my lord, his claim is that, my lord, since he is possessing that particular land under DAG number 296, my lord, therefore he should not be disturbed by while executing the order passed in 144 case, that is in our favor, declaring our possession. My lord, over 448 DAG number, and this order is based, my lord,
Page 25.
25, my lord.
So you both had filed respective 144 petitions?
No, myself, my lord.
You had filed.
And his ancestors were the parties there, my lord. That is
So this document at page 16
Yes.
is filed by you?
Yes. Yes, madam.
They have filed.
Yes.
Gopal Das.
My lord. Yes.
That is you?
Yes, my lord.
R6.
Yes.
All right.
And these
second to 9 parties are the ancestors of the petitioner?
Yes. My lord, that is the dispute, madam. We are saying that we are not connected with these persons.
My lord, so
we are not made party.
No, that's correct. I'll place, my lord.
Oh, so you are saying they are not ancestors of you?
No, madam. They are from the same village, madam. We are from the same village.
All right.
Now, my lord, so far 144 proceedings.
I am just right now trying to understand the facts.
Yes.
Either of you is at liberty to just let me know the facts. Only facts, no disputed.
Correct, my lord.
Yes.
My lord, so far 144 cases concerned, that was disposed of by page 25, my lord. By order.
25.
By order dated 23/9/2011, my lord.
Let's see that. Page 25.
Yes, my lord. This is type copy, my lord.
Yes. Read.
My lord. Both the parties filed hazard today and so and so. The proceedings started on a petition submitted by Sir Gopal Das and other police report there on the existence of possibility of breach of peace and tranquility between two parties. The petition of first party inter alia states that the plot of land measuring 153 biga, 4 kotha 16 acres covered by Dag number 421 old 448 new Dag at village number 2 Suktaguri Moza. Sipoja was allotted to by the government in their favor in 1956, and subsequently the circle officer Momole handed over possession thereof in 1971, and since then they are in continuous possession of the said land by cultivating and growing several crops. They are also paying land revenue etc. regularly. The OP of dubious nature and origin of are encroaching upon certain land in the western side of the disputed land and trying to dispossess the first party. With the intention of 4/11/2004, the first party members, while going to plough their access by OP, such incident took place again on 28/11/2004 and 3/12/2004 also, that there is every possibility of breach of peace and tranquility and may result in loss of property and injury of human life. Hence the petition. Police report confirms the same apprehend, hence a request to draw up a proceeding under 145 CRPC. Accordingly, the proceedings started. Scheduled land of disputed land measuring 153 biga, 4 kotha 16 less.
But these are not 290, not 296 or 448. Or 448 is there.
Yes, 44 in our favor. The government, my lord.
448 is there.
Yes.
448 is there.
Yes, my lord. 44, my lord. So far, this was allotted to the members of respondent number 6, my lord. This is our case, my lord. And in this writ petition, my lord, before that, my lord, and the page 27.
Sharma, I think let me hear the petition. It shall not be fair. Yes. What is what is your grievance, Mr. Counsel?
My main grievance is that after passing of this order at page 25 and extra 2, that was, my lord, again, my lord, it was upheld by the Honorable High Court. A lordship will find it.
Appeal was filed.
My lord, revision, my lord.
Revision was
A revision was filed. Where is that order?
Page 34, my lord.
No, now by this order, what has been mentioned? It says
your lordship will find at page 27.
On perusal of all the statements.
Before that, my lord, thus it appears that the DL and the land stated to be in possession and revenue paying of the second party members are
distinct and separate from the disputed
DL.
land.
Yes, madam. Peruse the report submitted by CEO dated so-and-so, wherein it is stated that the DL area of so-and-so.
Basically, the lands of the respondents in that 144 proceeding is separate, is distinct and separate. Correct?
Madam. Now, madam, what they are trying to project, my lord, after passing this order, since the criminal petition, it was upheld by the court, they are trying to encroach our land on the basis of this
orders, my
Let
lord.
us now show me where is the order of this court. The revisional order.
My lord, at page 34, my lord.
30?
Annex 3.
34 minutes.
34, my lord.
Yes. You challenged this.
This, not me, my lord.
Those
The
respondents.
second party.
But it was said that their land is separate. Then why?
My lord, they are trying to encroach our land on the basis of this order, my lord. That was our grievance, my lord.
No, I am not. It is not. Mr. Counsel, I'm not still clear with the facts. It appears that you had filed a 144 proceedings.
No,
where-
we filed.
They
You
filed
had-
number 6, my lord.
You had filed a 144 proceeding wherein certain people were arrayed as respondents. Correct? Now, the court in that 144 proceedings, after conducting an inquiry, it was found that your land is separate and distinct. And the rest of the people who are arrayed as respondents, their position is not clear.
Yes.
This is what that order
yes,
says,
yes,
correct?
Yes.
Now, this order was put to challenge by them.
Not by us, no?
By them before the
By their ancestors, by those respondents, correct?
before the honorable court, my lord, in a form of
Revisional petition.
Yes, my lord.
And in that revisional petition, what did
Our
this court
possession
do?
has been upheld, my lord.
Upheld.
Yes, my lord. Our possession, that order passed by the district magistrate has been upheld, my lord.
Yes. Now what has happened?
Now, my lord, his case is that, my lord, while executing this order of the additional district magistrate and the honorable high court after revision, they apprehend that they may be evicted from their land. 296. They apprehend, my lord.
But that
This
is
their
not even
But this
subject
is-
matter.
Yes, my lord, this is separate land. So therefore, the question of, my lord,
What
does
is
not
the
arise.
basis of your apprehension?
My lord, a notice was issued to us, my lord. Kindly see, my lord.
You respond to the notice.
Yes. We have responded, my lord.
Then?
After, my lord, getting no grievance, my lord, redressal, my lord.
No, notice was given for what?
My lordship may come to page 51, my lord.
Your challenge is to not to interfere with possession of the land of the petitioners.
Yes, my lord.
Measuring 448.
That is wrong, my lord. That prayer cannot be made, my lord.
Yeah,
Because
but
they are paying land
one
revenue.
second, one second. It has the additional district magistrate has already come to a finding that 448 that number is in the possession of Mr. Golab
Yes, Gulab Das.
Golab Das. Then how do you want this? How can this court, by way of a 226 petition, direct a mandamus and disturb that finding of the ADM, which has already attained finality after the revisional court has upheld the decision of the ADM?
And they have not gone to SLP, my lord, against
Then-
that.
No, my lord. We are not
First,
the
address this as regards your prayer number 1.
my lord.
This has already attained finality.
Right.
How can this court now? This prayer on the face of it is absolutely fallacious.
Right, my lord. And moreover, my lord, page 47, they are paying land revenue in different 296, which is their document, my lord. Page 47, my lord.
The
296
second
they are
prayer
paying.
again, 23-9 passed by the additional district magistrate is
Are
not
binding
binding.
upon us, my lord.
How can that be?
My lord, lands are different. They are
See,
trying
whether
to
lands
not
are different,
encroach
not
upon
different,
us.
this court is not going to go into it.
Yes, ma'am. That is true.
As far as DAG number 448 is concerned,
Yes, madam.
there is a clear finding of the additional district magistrate which has been upheld
madam.
by this court in revisional jurisdiction.
No, no. Lordship,
Correct?
yes, ma'am. Sorry.
You have not challenged that.
No, madam.
You haven't gone to
We are
Supreme
not the
Court.
parties, dear madam.
Even if you're a party or you're not a party, that order stands. There is a clear finding.
Yes,
Correct?
madam.
And who are these respondents? According to them, they are your ancestors. You are disputing to it.
No, madam. They are not our ancestors. He is raising this point, madam. Well, Lordship, kindly once come for a moment, madam. But the last annexation, madam. page 52. What is the report?
Where is the notice? Give me the notice. The notice. You said you have received some notice.
No, not notice, but this letter was issued. I am coming, madam. Kindly come to page 52, madam.
Page?
52, last page, madam.
This is some affidavit.
Madam, kindly see, madam. This is the order, madam. Passed by the...
Mr. Counsel, please address this court as what occasion that you had come before this court.
Yes, sir.
Why are you before this court?
We are
Please address this specific query from the writ petition, not from some affidavit.
Yes, ma'am.
Yes.
But on the basis of the order passed by the Regional District Magistrate, which was upheld by the Honorable Guwahati High Court, on that basis, madam, they are trying to encroach our land.
Where from are you showing it?
Madam, in that village, madam, they always used to...
Mr. Counsel, I am asking you from the petition to show me that part. Where have you said?
Yes,
or has anything been done?
We have said, madam.
Where is it?
Madam,
has any notice been given?
No, madam.
Because otherwise it's a premature writ.
Madam.
Effective 296, my lord, there is no. Because this is...
It's unfortunate.
Madam, para 9, madam. Para 9, page 10, madam.
Yes.
May I read, madam?
Yes.
That the petition based to state that order dated 23/9/2011 passed by the Garnet Regional District Minister Dorong, which has been confirmed by this honorable court in criminal petition number so cannot in any manner affect the right of the petitioners vis-a-vis the land in possession of the petitioner. Apart from the fact that the land claimed by respect number 6, the aforesaid proceeding itself has been held to be distinct from the land of second party, the said case. The order passed in the said proceeding cannot be used as a measure to
This you are giving a submission, but where have you said that the authorities are trying to evict you from your land? Where is that averment? Mr. Counsel, please be specific to the queries that has been posed. A very specific query has been posed. If you are coming to the court, you have to be a person aggrieved?
Yes.
Yes or no?
Yes, ma'am.
Now show me, how are you aggrieved? What is your grievance? This is what this court has been repeatedly asking. This is a submission paragraph.
Madam, page 51, I
Page?
Page 51, madam. This was the letter, madam, issued by the Regional District Minister to the officer in
Page
charge.
51.
Hello, 51, madam.
There is no 51.
Madam, 51.
Meganko.
Annex of 5, madam.
Your petition comes to an end at page 49, 51.
Yes, madam.
Are you referring to 24/9/2015?
Yes, madam.
This is at page 48, I think. The pagination appears to be different. Anyway, yes. What is this? Read.
This was issued to the officer in charge. With reference to the above, I am to state that despite various communication directives sent earlier, no action has been seen on the ground towards the execution of the Honorable Guwahati High Court order dated so-and-so passing so-and-so. It may be mentioned that the Guwahati High Court had ordered the said order has been upheld.
Yes, what is wrong in this?
Yes, madam.
After disposal of the criminal petition, madam.
The police person used to come every day.
Are you saying that Dag number 448 is yours?
No.
Are you saying that?
Yes, madam.
Dag number 448 is yours.
It's a big area, madam. It's a government land. Basically, it's a government land. It's neither our land nor his land, madam.
Are you in possession in Dag number 448?
Yes, madam. We are also in the.
But then the ADM report shows them to be in possession of 448.
Yes, I think it's a big land, madam. That land comprises of area of 153 bighas of land. It's a big area. It's a government land, basically, madam. And if your lordship come to the last page, madam, last page, a report.
Mr. Counsel, how will this court go into all these questions?
No, madam.
Malad, under 145 Malad of CRPC, that clause 6A, it provides Malad declaration given by additional Malad district magistrate or upheld by the honorable court in criminal petition
this declaration of possession subject to filing of my lord civil suit. And civil suit, if he has such a ground, then he could have approached my lord that civil court, showing that.
I don't
so
think you
far
have
the
any
my lord,
case. Mr. Counsel.
my lord, 145 my lord, clause 6A my lord. If,
6A, yes.
If the magistrate decides that one of the parties was or should be under the proviso to section 4 be treated as being in such possession of the said subject, he shall issue an order declaring the party to entitled to possession thereof until evicted therefrom in due course of law, my lord, and forbidding all disturbance of such possession until such eviction. My lord, when he proceeds and provision for he may restore possession, a party forcibly and wrongfully disposes. My lord, so far the understanding is that, my lord, that declaration of possession by district magistrate is subject to the decision of, my lord, in civil suit filed by the parties. Now, my lord, if he has such ground, he could have approached. Because as of today, my lord, possession is has been declared in our favor, my lord, by two honorable courts, my lord. And so far his submission, page 47.
He is saying that he is not a party in those proceedings.
My lord.
Number one.
My lord.
Okay. And now, suppose he is not a party and this has been decided in his back.
My lord.
Whether he is binding, whether it is binding on him.
My lord.
Because he is not a party.
My lord.
Admittedly, he is not a party.
His predecessors or his fathers, I have stated in the petition, my affidavit. He was represented. They are the sons now, second time they have.
From where do you show that?
Yes. My lord, yes. And so, yes. Affidavit, my lord.
Affidavit in reply or opposition?
My lord, affidavit in opposition, my lord. Page 8 of the affidavit filed by the respondent number 6, my lord. Preliminary objection number 1, my lord. Yes. That the petitioner has suppressed the fact that the miscase number 13/2005 was instituted against Dave Fruites, who tried to encroach the land of the respondent number 6 in December 2004. The petitioner number 6, Mohir Ali, son of Kismat Ali, was represented in the miscase number serial number 3.
Who is the petitioner here?
Yes.
My 24 numbers, my lord.
Huh?
24 numbers, petitioners.
In the miscase means, my lord, that page
all the petitioners you have demonstrated were represented.
My lord, yes, my lord, because some of their fathers were there at that time. Father expired, now the sons has come, my lord. Page 16 of the writ petition, if I correlate with the page 8 of my affidavit in opposition, my lord.
Page 16 of the writ.
Page 16 of the writ petition, this is the original application, 144.
Yes, please.
My lord. Now here, at serial number 3,
Kismat Ali.
Kismat Ali, my lord.
He is petitioner number 6 father.
Yes. Yes, my lord. And the petitioner number 17, 18, 19 were are the sons of Rahimuddin. They were the brothers of Harez Ali, whose name
This
appeared.
petition appears to be a frivolous one, Mr. Counsel.
No,
Huh?
no, my lord. No.
Please be mindful, otherwise cost will be awarded, because it appears that the...
We have filed our reply, let him submit.
No, but it has been demonstrated that you have been represented and you are you were present in the proceedings of 144. Those proceedings were put to challenge and it was already upheld. Now after that, how can you again come by way of a writ petition?
We have
Where when the question of execution of these orders are in question,
Yes,
and
that's
has he taken stay?
They have, my lord, because not to evict them, my lord,
and
without...
obtain stay in your favor. This appears to be a gross abuse of the court process, Mr. Counsel. Please convince this court. Otherwise, serious costs will be awarded, I'm telling you. Because it appears that you have been represented.
We have filed our reply also, madam.
What have you said? That how have you controverted the paragraph, Roman paragraph 1 of paragraph 3?
Madam, in our reply, madam.
Yes.
Page 2, paragraph 5. And with regard to the statement made in paragraph 3, Roman 1 of the affidavit in opposition, I do not admit the same. It is denied that the petitioner tried to encroach the land of the respondent number 6 in December 2004.
That is a different thing.
But the petitioner number 6, Mosir Ali, did not represent in this case number so and so, as stated by respondent number 6. The same is a false statement, madam.
The disputed question of fact will come, my lord, in such
Mr.
cases.
Roy, you are appearing for the government?
Yes.
What is to be done?
Government has affidavit. Yes, sir. They have filed their affidavit.
By paragraph 4, Lordship. Kindly be second part, Lordship. It may be kindly be stated that the plot of land in question covered by DAG number so and so 4, that question DAG number, Lordship, 448, was attached by the additional district magistrate Darang under section 145-46 of CRPC in connection of the miss case number 7 due to apprehension of breach and peace. And finally, wide order dated additional district magistrate Darang concluded the proceeding by way declaring the possession in favor of the respondent number 6. And 5, Lordship, that with regard to the statement made for instant writ petition, joint report of the circle officer Sipajar Revenue Circle and OC Sipajar PS LR staff along with the police came to the land under DAG of 440 of that DAG, and they found that and handed over the possession to the respondent number 6.
This you are reading from your affidavit. Where is that affidavit?
Affidavit filed by respondent number 2. They have not filed any reply to that.
Affidavit to Mayanko. I'll get mark for you. No reply file.
No reply file.
Mr. Gogoi, which matter are you waiting for? One more hearing is there.
108.
Paragraph that
4,
you just read.
Paragraph 4, second part. May I read, ma'am?
Yes, please.
Second part, Lordship. It may kindly be stated that the plot of land in question, covered by DAG number so and so 421 old and 448 new, was attached by then additional district magistrate Darang under section 145-46(1) CRPC in connection with the miss case number so and so due to apprehension of breach of peace and finally wide order dated so and so. The additional district magistrate Darang concluded the proceeding by way of declaring the possession in favor of respondent number 6 herein by judgment dated so and so, and in criminal petition number so and so, Honorable Guwahati High Court pleased to confirm the judgment passed by the additional district magistrate. Now 5, Lordship, that with regard to the statement so and so, the answering deponent begs to state that as per joint report of the circle officers, Sipajar Revenue Circle,
So it has already been handed over to the R6. You have already got it.
And Lordship, para 11. Instant writ petition, the answering begs said that as per report of the circle officers, so and so and land in question neither belongs to the petitioner nor in the possession at the time of filing this writ petition.
So there is a clear finding
Yes.
that this land does not belong to you, and no rebuttal to this para. I'm just sorry.
Madam, kindly give me some time, madam.
Some time for what?
For showing some documents, madam.
So you should have had those documents. The matter was listed for hearing.
Kindly come to the last page, madam, of my petition, madam.
Yes. Yes.
the last page of the requisition, madam. This is the order of the circle office, madam. May I read this order, madam?
Yes, please.
And order dated 17.
Order dated?
Order dated 17/2/2015. Both the parties are
One
present.
second.
Madam.
Annexure?
Annexure 6, madam. The last page.
Yes, order dated 17/2/15.
Yes, madam.
Yes.
Both the parties are present. On hearing from both the parties, it is found that the first party is not willing to for amicably solution, despite the fact that their claim on the DL for having possession is found to be untraced. Although the first party has been claiming to be allotted land on the DL, they do not have any possession for last 40 years. And although supposed to be allotted, they could not produce any valid official allotment documents record in respect
Who
of
is first party here?
But they are, that's number 6.
Where is it mentioned? I can't find anything.
There is nothing, Lordship.
Where is their name mentioned in Annexure 6 page? First party. Who is first party? How do we know who's first party, who's second party?
Further, Lordship, in which case this is filed, there is nothing, Lord, no reference.
You brought in this certified
reference
copy
is
of the
there.
order, which does not have any reference of any case number, any name of the parties. How do you want this court to take notice of this document? Who is first party? The state government's affidavit is absolutely clear that you are not in possession of the dispute of the subject land.
It's a huge plot of land, my lord.
Maybe, but you have to understand before which forum you are. How can this court go into all these questions?
This order is to the circle officer.
If you, Mr. Counsel, if you had a case over that subject land, you could have gone to the civil court and got a declaration.
Yes, we haven't gone, my lord. But
you haven't gone. Why?
Because, my lord, because we are not the second party. They have not aided us as second party.
Mr. Counsel, it is very difficult when you do not address to the questions that are being put. For going to civil court, you don't need to be arrayed. I'm not asking you to go for an appeal, but you could have. If you are saying you are the one who is in possession of DAG number 448, then for that you have to go and get a declaration. Have you done that?
No, that we have not.
You have not done that. Secondly, there are orders of the additional district magistrate which have been upheld by this court, which shows that the respondent is in possession of DAG number 448. The affidavit of the government loud and clear says upon inquiry of the circle officer, they have found them to be in possession. In fact, they said that you are not even in possession of this land and you are no way connected to this land. Now, if these are the facts before this court, how can this court grant you any relief?
Our court is defined, my lord. The DAG numbers may be same, my lord. It's a huge plot of land.
DAG number 448
is also in our possession, my lord. A part of, not the entire DAG, my lord. A part of it. And Lordship, your Lordship may see our reply, my lord, which we have filed. There is an RTI reply by the government, my lord. The reply filed by us, madam, to the affidavit opposition filed by reference number 6.
All right, please take your seat.
My last document, I'll show you. This is the last document. I'll show you.
Where?
To our affidavit in reply, madam.
Affidavit in reply? There are two affidavit in reply or one?
One, madam. To the reference number 6, madam.
Page number?
Page number 8, madam. Page number 8 is the...
Page number 8? There is no affidavit in reply. There is one affidavit in reply filed by the petitioners, but there is no page number 8 here. Sure. Sound?
এটা নকৰে তো 96 কো ডিস্টার্ব হ'ব নালাগে বুলি পঢ়ি নলব এইবিলাক কি দেখাইছো কিবা কমিটি আছে না এইবিলাক কিয় লাগে ইউৰ
20.
My submission is that, my lord, since he in his petition states that he is paying the Tozi revenue in respect of other land, my lord, perhaps his prayer may be, my lord.
Where has
Page
he
47 of the writ petition, my lord. This is the revenue receipt, Tozi revenue receipt in respect of, my lord, page 47, 296.
296, but this is patta number.
Annual patta, yes, my lord.
Not DAG.
Yes, sir, sorry, my lord. And annual patta, this is, and another
So
annual
why
patta,
should
my lord.
court get into this?
Yes. So his land is different, my lord. So I was saying
See,
that.
you see, he has only challenged these two
Yes.
orders. Now, it appears that the persons who were present were connected to him. So that means he has been represented. But whatever be it, those orders have attained finality.
Yes.
Now he wants an order that which is not binding. But those orders are in reference of 448.
Right.
And there
He
is a
cannot
clear affidavit filed by the state government saying he is not in possession of 448. So then he cannot be said to be a person aggrieved.
Right. Obliged.
What's my spirit is the last document, madam. Everything in reply, we have filed, madam.
Application seeking information.
Yes, madam.
Under RTI.
Yes, madam.
Yes. Then what happened?
Madam, information regarding number, madam. Information.
All right, this is your seeking information. What happened after this?
Madam, their answer has come, my lord, at page, madam, 10. It details, number 1, as per record, the land under Sipada Mura number so and so, dark number 448, the total land of 153 bighas of land is government land, is seen. No allotment is given public seen to any person to the above mentioned land as per office record.
So this also shows that it is not with you.
No, madam. Yes, madam. It shows that, I am trying to convince your lordship, madam, that the land under 448, madam, the entire land is a government land, madam. It's not that it's a patta land.
How does this document help you, Mr. Counsel? How does it help you? Does it show that you are in possession?
No, regarding...
No, does it show you are in possession?
No, madam.
No. Then you want this court to give a finding, issue a mandamus to the effect that the orders of the ADM and this court is not binding. Correct? How do you want this? How do you want this court to give that?
Not to disturb our land, my lord.
That is not your prayer, Mr. Counsel.
Yes, madam. Yes, madam. My prayer too, madam. My prayer, madam.
Prayer 2 is a declaration that the order dated 23/9/2011 passed by the Additional District Magistrate Dorong Mongoldoy in so-and-so is not binding upon the petitioners. That is your prayer number 2. Then prayer number 1 is not to interfere with possession of the land of the petitioner measuring 109 bighas covered by DAG number 448. Covered by DAG number 448. Government has already said that you have no possession in 448. How can this court grant this prayer? Heard, Mr. SP Das, Learned Counsel for the petitioner, stop. Also heard Mr. BK Das, Learned Counsel, appearing for respondent number 6. And Mr. SS Roy, Learned Additional, Learned Junior Government Advocate for the state respondent. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is seeking direction inter alia to the respondents not to interfere with possession of the land of the petitioners measuring 109 bighas covered by DAG number 448 of village number 2, Suktaguri under Moza Sipajar, Darang, and for a declaration that the order dated 23/9/2011 passed by the Additional District Magistrate Darang, Mongoldoi in Miss Case number 13 of 2005 is not binding upon the petitioners. Stop. The petitioners, being 24 in numbers, have filed the present writ petition projecting themselves being aggrieved by the action of the respondent authorities in purporting to evict / dispossess them from land over which they are cultivating for the last more than 4 decades. Stop. Mr. S.P. Das, learned counsel for the petitioner, submits that in view of the order passed by this, in view of the order passed by this court on 22/2/2012 in criminal petition number 595 of 2011, whereby the order of the ADM, Dorong, dated 23/9/2011, declaring possession of the subject land measuring 153 bigha, 4 kathas and 16 lecha, covered by Dag number 448, was issued, the respondent authorities are seeking to execute the said order. Stop. He submits that the petitioners apprehend that if he submits that the petitioner are in possession of land in Dag number 448, and in the event the district administration executes the aforesaid orders, the petitioner shall be evicted. Later on, you've taken note. Petitioners shall be evicted. Stop. Fearing the same, the present writ petition has been filed. Stop. Mr. B.K. Das, learned counsel for the respondent number 6, on the other hand, vehemently submits that the petitioners are not in possession of the subject disputed land, which is covered under the order of the ADM dated 23/9/2011, which was upheld by this court by order dated 22/2/2012 in criminal petition number 595 of 2011. Stop. He accordingly submits that the petitioners he further submits that the order of this court having attained finality cannot be reopened by way of the present writ petition. Stop. He further submits that the petitioners cannot be said to be an aggrieved person, and therefore the present writ petition is not maintainable. Stop. Next. Mr. S.S. Roy, learned junior government advocate, submits that in connection submits that the plot of land in question covered by DAG number 448 new was attached by the then additional district magistrate Dorong under section 145/1461 of the CRPC in connection with miscellaneous case number 13/2005 due to apprehension of breach of peace, and finally by order dated 23/9/2011, the additional district magistrate Dorong concluded the proceeding by way of declaring possession in favor of respondent number 6. Stop. He further submits that subsequently by judgment dated 22/2/2011, this court in criminal petition number 595/2011 uphold the aforesaid order of the ADM Dorong. Stop. He further submits that as per the joint report of the Circle Officer Sipojar Revenue Circle and OC Sipojar PS, LR staff along with police visited the land under DAG number 448 of number 2 Suktaguri of Sipojar Revenue Circle and handed over possession of the said plot of land to respondent number 6. Stop. He further submits that as per report of the said circle officer, the land in question does not belong to the petitioner nor is in the possession of the petitioner at the time of filing this writ petition. Stop. Heard the parties and perused the documents available on record. Stop. It appears that the learned executive magistrate on 1/2/2005, upon considering the police report as well as the non-FIR submitted by the respondent number 6, recorded his satisfaction that there was every likelihood of breach of peace and tranquility between the parties and drew up the proceeding under section 145 CRPC. Stop. Thereafter, the additional district magistrate Dorong, by order dated 23/9/2011, disposed of the proceedings by declaring the possession of the respondent number 6 with a direction to the petitioners / opposite parties not to interfere with the possession of the respondent number 6 until ordered otherwise by a proper court of law. Stop. It pertinent that while recording such finding, the learned magistrate considered the petition submitted by the respondent number 6 as well as the written submission submitted by the opposite parties who are related to, they are related, right? That is what you have shown.
Yes.
Some of whom are related to the petitioner.
Yes.
Herein. Stop. The learned magistrate, it further appears that the learned magistrate also took into consideration the extensive evidence adduced by both the parties. Stop. In addition, written arguments of both the sides were also called and perused. It further appears that the learned magistrate also considered the police report, the report of the circle officer and that of the Gaubura. Stop. It further appears from the report submitted by the circle officer that the disputed land was possessed by the respondent number 6 and the total area of the disputed land is 153 bighas, 4 kathas, 16 lecha. Under dag number 44, old. Dag number Nakoba. So and so.
On a 421 old, my lord.
Huh?
421 old and 448 new, my lord.
Okay, I'm not going there. It further appears that after an overall assessment of the above, the learned magistrate took the view that the disputed land and the land stated to be in the possession of the opposite parties are distinct and separate and declared the possession of the respondent number 6 over the disputed land. Stop. Being aggrieved by the aforesaid decision of afforded order of the learned magistrate, an application under a revision petition and an application was filed under 482 of the Criminal Procedure Code, being Criminal Petition number 595 of 2011, wherein this court by order dated 29/12/2015 was of the considered opinion that the view taken by the learned magistrate is a plausible one and therefore that no infirmity is found in the order of the learned magistrate dated 23/9/2011. And accordingly dismissed the application by upholding the order of the learned magistrate. Stop. Pursuant to the aforesaid order of this court on 22/2/12, the Additional District Magistrate Dorong Mogoldoy by order dated 24/9/2015 directed the officer in charge Sipojor Police Station to execute the order of the ADM Dorong dated 23/9/2011. Stop. The writ petitioners projecting themselves to be in possession of the disputed land filed this instant writ petition apprehending that pursuant to the aforesaid order of the Additional District Magistrate Dorong Mongoldoy dated 24/9/2015 shall be evicted. In the present writ petition, the following prayers have been sought. Page 13. Tick mark kore disu. Tololeke. Tick mark 1 and 1 which are reproduced here under for ready reference. Stop. It appears that the petitioner is seeking a writ in the nature of mandamus for declaration that the respondents for declaration inter alia that the respondents not to interfere with possession of the land of the petitioners measuring 109 bighas covered by Dag number 448 of village number 2 Suktaguri under Moja Sipajar Dorong. Stop. It further appears that the petitioner is also seeking further direction to the effect that the order dated 23/9/2011 passed by the Additional District Magistrate Dorong Mongoldoy in Miss Case number 13 of 2005 shall not be binding upon the petitioners. Stop. It appears from the affidavit in opposition filed on behalf of the respondent number 2 on 22 August 2017 that the petitioners are not in possession of the subject plot of land. Stop. Paragraph 4, 5 and 11 of the aforesaid affidavit in opposition are reproduced hereunder for ready reference. Edu tumi paba a pink flagot page 108 ot prarambho hoise affidavit khon. There. Mark koriba. Stop. Pertinent that the aforesaid averments made in the affidavit in opposition filed by the state respondent is not rebutted by the petitioner. Stop. In fact, no affidavit of reply, no rejoinder has been filed against the said affidavit in opposition. Stop. That being so, the factum of possession of the petitioner over the subject disputed land is not established before this court. Stop. Is not established. Stop. In such event, the prayer sought cannot be granted by this court under Article 226 of the Constitution of India. Stop. Therefore, this writ petition fails. Resultantly, fails. Stop. With the aforesaid fails, resultantly the writ petition stand dismissed, no cost. Interim order passed earlier shall stand vacated. Yes, what is this?
Lordship, actually, Lordship, I have urgency, but Lordship, today I have to take some time, Lordship. I have to some more preparation, Lordship.
Correct.
Matter is very small, Lordship.
You have some difficulty today?
Difficulty, Lordship, perhaps I have to take some judgment, help of some judgment, Lordship.
Your name?
Yes, Hawk, Lordship.
Mr. S. Hawk, learned counsel for the petitioner, submits that he may be seeks accommodation for placing few judgments of the apex court in the issue in hand.
Yes.
Stop. Fair is not opposed. List this matter again on such and such date. All right.
Obliged, Lordship.